Hello?
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Dati mihi Anglican for each service Latino.
Is that correct?
Literally not true.
I didn't ask you to interrupt me.
Oh, for crumb's sake.
Good morning, good Saturday morning to you. Welcome to the Court of Public Opinion. I am the Recovery Addict. Wonderful to have you all out here on this bright and shiny weekend. But yes, we are back in court today. Let's see, there I am. Whew. Ready for some spice. Oh, aren't we all? We're going to get the spice today. I'm pretty sure. I'm 95% sure we're getting spice. So happy to be able to witness that with y'all. It is fancy to see y'all here on a Saturday. Is this what you guys look like on a Saturday? I'm looking out across the audience and I see everyone in their jammies curled up on the couch with something comfortable, snuggling with them like a pet or a blanket, and their significant other, I guess, would count as well. Welcome. Laughing Disco Ball. Thank you, Elated. Appreciate that. Big shout out to Snow Leopard X, which is an operating system for Mac. Still Pink, Almost Red. 30 months on the jury. Thank you very much. Appreciate that. We also have Lily Balm. Lily Balm. I don't remember. This could be my poor memory, but I don't remember you ever winning before. And by winning, I mean losing. It shows you were first in chat today, and about that, thank you. We're going to punish you for your promptness. Everything IP related worldwide is your responsibility. Yes, your punctuality and promptness has earned you that punishment. First time winner. That is amazing, Lily Balm. You're going to do great, Lily. No concerns whatsoever on our part. I hope you have a lot of free time today because the internet is your responsibility. The calls will be flooding in as they do. But thank you. PJs and Diet Coke for me, says Selena. I'm on the couch with a flannel shirt I'm fixing. I have my cat and a blanket. I'm telling you, I can see you. The internet's, the technology is wonderful. I'm able to see everything that is going on. There's Lily Balm with the winning comment. Lily Balm, you need to screenshot that for proof. Let's see. How did your children fare with our road angel? Oh, guess what? The road angel's name was Scott, which I think is a great name. But they were pushing their car on the side of the freeway near Wendell, Idaho. I'm not sure if they were headed to Idaho Falls or Boise or wherever. And Scott's like, no, that won't do. Scott wasn't just like driving around thinking, I wonder who I can help on the side of the road today. He was frantically trying to get his son to a baseball game. And he saw my kids and said, nope, this is more important. And he stopped and helped them, got their car to a shop that he knows and trusts and can help them out, and then waited with them until my daughter-in-law's parents were able to meet up there. Just like, what a stud. What an amazing guy. So now we're going to figure out if it's worth fixing the car, or transmissions aren't cheap, so we'll figure out what to do there. Wolf, thank you very much for the Wolf. I love it, with the microphone and everything. We also got some sunshine in there. 35 months from Meg Osborne on the jury. Thank you, Meg. Appreciate your support. Let's see. Let's get court ready, shall we? There we go. Universe confirmed all Scots are awesome, said Bunny. I think I missed a couple little gifts. They disappear and I can't see them anymore. Apologize for that. I've got like 3 seconds to catch it, otherwise it's gone. So yeah, just a really cool guy. We added him to our thoughts and prayers recently and his reasoning for doing this, he said, because my wife talked to him, called him, and said, I've got kids your kid's age, and I hope that if they're ever in trouble, someone to do it for them. So he's like putting the good vibes out into the universe. I'm like, that is just what an amazing guy. Looking forward to some spice today. Thanks for working overtime, RA. Thank you, Kimmy. Thank you for being here as well. You're on the clock as well. Don't think that I'm here on by myself. I see all of you here. So, anyone here play old school RuneScape? Well, that's going back to the day. I never got into RuneScape. Never got into that. All right. Let's see. I think we did all Saturday birthdays yesterday, so no song today. We did. We sang to everybody that I know of. So we can skip the song knowing we've already celebrated the birthdays. Unless somebody here desperately wants to be sung to again. Is this Kathy's birthday? Is Kathy here, though? We're saying twice. Right, Kathy got her own song. Katerina's Scarcella. Did I say that right? Katerina Scarcella. I think it's Katerina Scarcella. Thank you very much for the super chat. All the lowercase letters, I can't tell them apart. Is that legal, though, to skip the birthday thing? Is it legal? I don't know. Thanks for the Sunday. Limerick Galuza. I love your names. I just don't know how to say them. All right. You will all sing and dance and like it. Well, since we're early for court, we'll do it very quickly. One verse. But is there anybody? Oh, I don't know. Court's about to start. I don't want to be the one that makes the judge mad today. He's not super happy being here on a Saturday anyway. She didn't get the drum solo. Well, she wasn't here on time either. I mean, I can throw that back to Kathy as well. Kathy's on her own stream. Okay, so happy birthday, Kathy, and others as well. I want the end part. I can't fast forward. I'd have to play the entire song to get to the end part. There you go, drum solo. All right. I did not know we were going to be here today, so you sang to me yesterday. Jen Pookie, happy birthday today as well. It's wonderful. We did sing yesterday. We'll see what happens. We might later on. Aaron Blackman says, all right, how do I set up a day or time, or what's good time to call the burner or get some NC advice, ins and outs? By the way, I'll be working at Cherry Point. Awesome. Cherry Point's cool. I never went. I could have gone on Cherry Point when I had a CAC card when I was working here for the Department of Defense, but I never actually went in Cherry Point. I wanted to because I heard they have a beach in Cherry Point.
Hello.
Or maybe it's I don't know. One of the bases down there has a beach that people say is excellent for metal detecting for Civil War finds. The only problem is you also find modern unexploded ordnance, and so they wouldn't let you metal detect anymore. So I never went there. But Aaron, anytime we're not live is basically when I can answer the burner phone and talk for a while. All right. Why are they in court today? This is a great question. This is an excellent question. Why are they in court today? The judge is super worried. This case was supposed to be fast. It was supposed to just take a week. And the prosecution still has not rested their case. So things are going slower. I would say it's because the defense is challenging things, which they have the right to do. So defense has put some roadblocks up that have slowed things down. Well, the judge is unhappy with that because this is a jury trial, and this next week is a holiday in the United States, and it's a big one. It's one where it's going to be like a 4-day weekend type situation, and the judge is very worried that this jury will be out and about in the world for 4 days with family and friends and get-togethers and, hey, what are you doing lately? Oh, I'm on a jury. There's a problem there. there's a good potential for jury to be compromised, and at the end of the trial, just think of all the wasted time that would if we went to mistrial for that reason. So he is trying to get this done before the holiday, which means we've been working late. We're working the weekend, and it's been crazy. Kathy has great recaps. I love her takes. Sometimes a little spicy, but really good. John Davenport, member for 39 months. What a better way to spend a Saturday watching court and working overtime. Message me on your future home location. Let's hear it. OG, 39 months. John, stay safe and don't breathe in too much smoke. I know all of Utah's on fire right now. Weebug, member for 26 months, also an OG. Happy Saturday, everyone. Judge must have known it was my membership anniversary and gifted me with court today. It was just for you, Weebug. I saw the memo. It's in the court record. J. McCarthy World, excuse me. Member for 3 months. Love it. I think you've been here longer than that. But love it, love it, love it. I'm so worried the state won't be able to prove his guilt. There needs to be more. But I think they're saving the best to last. I'm hoping, because if this is all they have and this is what they brought the case with, I'm worried for them as well. It's not a big holiday, only America's 250th birthday. All right, about that. Have you thought of what's your present going to be, 80s? What's your gift to America for the 250th? I haven't thought of one either. So if you can't think of anything, welcome to my boat. Tennessee does not work on Sundays. It's the South. Right. It's going to be today only, not on Sunday. Plant a tree? Ooh, that's a good one. Maybe a white oak or an elm or something. One of the slow growth hardwoods. Those are great trees. Seems like nowadays everyone's into what tree can I plant and still be able to harvest in my lifetime so I can make money off of it. And that limits you to like evergreens, like pine trees and stuff. And pine's not the best wood. It's a soft wood. It's full of sap. It's just not the best wood. So gardening and watching Hamilton. That sounds awesome. Anti-ultra crepidarian. Thank you for the super chat, the high five. You guys are awesome. All right, we're going to be going to court in just mere moments. In the other room, Mrs. R.A. is recording an audiobook, so I have to not yell too much, or else she has to go back and re-record it. But my sister has some young kids who love audiobooks, and my wife has some experience recording audiobooks, so she's recording a book today. Got her set up this morning. That's why I was a teensy bit late, just like 2 minutes. It's a mini RA is a mini RA. Is mini RA a member of Daughters of American Revolution? Is that the one you have to prove a relationship to? Like you have to go through your ancestors and find that you had somebody who participated. Is that the one, or can just anyone support, just buy in? Because she's not on either count. But everyone use her indoor voice. Yes. Let's see. Yes, it has to be a genealogical tie. Dara needs proof. They have a similar one that's called Daughters of Utah Pioneers, where Utah was founded, 1847 or something, so very, very recently. And it was sort of like a traumatic start to a state, right? It's sort of a bunch of people came in mass and then tried to make a living out of a desert. And there's some great history back there, but their museums are incredible. The Golden Spike, from the Golden Spike where the railroads connected. And it's fun to go watch those things. All right. I could listen to her read a book. She's up there with Keith Morrison and Samuel L. Wow. A little Samuel. Whoa. Yes, you have to prove it. My ancestor was John Stark. He's my great cousin, was in the Revolution. I don't know. I'm going to have to look. Ancestor-wise, I think on my side, we pretty much came over from Scotland and England very recently, like 1900s. That's when my great grandpa came across. So, if we fought in the war, we might have been on the wrong side. Is that a problem? If we're tied to the other side of the battle, or do we still qualify? I'm sorry. It's just I might be one of the enemy. Is what I'm saying. Good times. As long as we can tie ourselves to the event, keep that part to yourself. I won't say the name very loud. Does it matter if we wore a red coat? Prosecution needs a bombshell in this case. Wildcats, I think they do. They need a smoking gun. They need a tie. We need something that can say Blaise asking friends for massive amounts of cocaine, or Blaise searching on the internet for drugs that will harm a pregnancy. We need some sort of connection, and we might get that sort of vicariously through his ex-girlfriend, Apple, who is supposed to be testifying today, and that is going to be spicy. Chris Wallace gifted a membership. Thank you, Chris, very much. Boo, redcoats. Blaise's pattern of behavior will be probative. I agree. That will help. I'm not sure how much they'll be allowed to get into because of the prejudicial nature of it as well. So we're going to be... Apple needs to hit a home run. Ancestry never sent me my results. It's been 4 months. Oh, no. It's a long time to wait. Coffer has their microphone.
Your Honor, just for at some point today, for scheduling purposes, I understand Mrs. Murphy is not here. At some point, I would like to make an offer of proof related to the information we were provided yesterday by the state. It's very brief. It will just be a proffer. Because Ms. Murphy's not here, I think I can wait to do it until she gets here so we can...
You need her as a witness?
No, I want to lodge some exhibits as an offer of proof, but I'll wait till she gets here. And just think before Ms. Denny testifies, I think, for timing purposes. It can be very brief, at lunchtime perhaps, or at a break.
Well, what if we don't get to the items the state gave you yesterday?
I'm not asking to make any sort of evidentiary argument. My expectation based on the conversation is that the cross-examination will be appropriately restricted. I just want to make an offer of proof related to that prior to the next testimony. Thank you.
Okay. All right. Where?
Just about went everywhere. Oh, they did. She lost it. They went off the other edge.
One just went in the restaurant.
She brought a lot of files today. I think those are the files for the 6 remaining witnesses, potentially for the prosecution. Casey Paralegal. Let us know what he wins. I think he's going to win. He's going to win. Steve and Lisa, welcome to the gallery. Thank you.
You come up here.
I wasn't sure. Thank you.
All right, the witness, remember when we left off, the witness was about to be cross-examined by the defense. Passing notes already this morning. Give me your pen. Not Big Mac, not quarter pounder with cheese. Yes, fish fillet. 1 fish fillet. Got it, fish fillet. Okay. They're just taking their order right now. objection, Your Honor, is here. 14 months. Congratulations. All right, I think we're still waiting for the witness. Who just took the stand, I think. Jury's coming in. Look at that suit the bailiff's got on. It's got a faint checkered pattern, barely detectable by the human eye, but it looks sharp. Went with the black tie instead of the orange. There's a lot of orange ties in Tennessee.
All right, good morning to you, ladies and gentlemen. Jury, let the record reflect all of the jurors are here and present. You'll wait for the right hand and you swear to tell the truth, so have you got it?
Yes, I do.
All right.
We're missing the clerk.
Questions on behalf of Mr. Taylor?
Thank you, Your Honor.
All right. Be prepared for spice. Let's see how this starts.
I just need to connect to the.
Okay.
Trying to fix up the audio here. Might have to rewind a tiny bit to make that happen.
Is it on, Your Honor?
Is it on? Oh, the objection counter. Oh, let's bring that up really quickly. There we go. We're at 100 right now. 100. Started an even number. Thanks for that, Denise. The coffee is spreading. This is the Super Spreader Ground Zero event for the courtroom coffers.
I can just use that. I don't want to hold them up, so I can just use that.
Lois, we heard you. We heard you. Let's petition all the courts to hold Saturday trials. That'll be fun. Yeah, the cough is spreading. It's going to be bad by the end of this. Olga Corona, thanks for the high five. Appreciate it.
Good morning, Dr. McDonough.
Good morning.
I'm just going to go back and forth, so I'd just rather use this one. I was speaking with her. To make it show that. How do I make it show?
Hit up the wheel.
Good morning, Dr. McDonough. How are you?
Good morning.
Good. I wanted to talk with you a little bit about the work that you perform at NMS, and specifically the work that you performed in this case.
Okay.
Could you tell us, or at least tell the jury, exactly what accreditations for NMS are important in terms of the things that you have to do at your lab in order to be accredited?
NMS has a number of accreditations because we work with so many different types of agencies, laboratories, and because we also do both clinical and forensic toxicology. So the primary accreditation I believe you're referring to is through ANAB, and it's to a standard called 17025. So ANAB stands for, it's a mouthful of acronyms, but ANSI, ASB, National Accreditation Board. And so what this entitles is that 17025 is a standard set forth on testing laboratories. It dictates rules on how the entire lab needs to be run, really. Rules and regulations on qualifications of the people who work there, the types of records we need to keep, how testing needs to be performed, documentation, things of that nature. So to be accredited, the laboratory agrees to these rules and agrees that they'll adhere to those rules and agrees to undergo surveillance and on-site assessments periodically, where outside agencies and individuals will come in and assess us to those standards and ensure we are meeting all of those standards. So that's the major and primary one, but in addition to the ANAB 17025, we're also CLIA accredited, which is a accreditation through hospitals and clinical samples. We work with the College of American Pathologists, or CAP, which specifically refers to more post-mortem type samples. And some states have their own individual requirements, and so we also meet those standards and accreditations and certifications for those individual states.
Thank you. Now, are there certain factors that the ANAB require from you in order to keep your accreditation? And what I mean by that is, let's say chain of custody. Is that something that is required in order to be accredited?
Chain of custody is part, yes, of ANAB standards.
And specifically when we're talking about forensic toxicology, correct?
Yes.
And that's one of the things that are extremely important.
Yes.
And what about storage in terms of ensuring that whatever vial or matrix, and we learned yesterday that matrix could be blood, urine, semen, whatever it is. What about the storage in terms of being refrigerated? Is that required, that it's stored properly?
It's required that you have a policy and procedure for the storage of your samples. The individual storage needs will vary based on the matrix.
Right. Let's say blood. How would you store blood properly to keep your accreditation?
So that's going to be based on your policy, and it can vary from whether you're talking short-term storage versus long-term storage. So short-term storage for most agencies is that the sample is still in the process of testing or may be tested very soon and readily. Long-term storage may involve being frozen.
Okay. When you, let's say it's a week to a month, would you store blood in a refrigerator?
Typically it is stored refrigerated, yes.
Are there ever times for a month that blood should not be stored in a refrigerator?
I mean, when you take it out to test it, it's going to be at room temperature.
Well, I'm talking about for a month long. Let's say you're not testing it, you're not doing anything with it, and it's a month period that you're not doing anything with it. Should it be in the refrigerator?
Ideally, it would be good to keep it cold, but the actual individual rules are going to vary agency to agency. A month may be a frozen capacity for some agencies. For NMS, it's typically while that sample is in testing, and for a short time after testing, it will remain cold and refrigerated. If it is deemed to go to long-term storage, it then typically gets moved to a freezer at some point.
Okay, and I'm not talking about when it's being tested. I'm talking about when it's just waiting. You know, it may be don't destroy it because we may need it later, and a month passes. The best practice is for it to be refrigerated and or frozen. Would you agree?
Cold, yes. Cold. I would agree cold.
Thank you. And that's very important in terms of the integrity of keeping that sample, correct?
Yes.
And then what about sealed? Making sure that whatever vial and or cup or tube that it's sealed with an initial so that it cannot be tampered with and to maintain the chain of custody. Is that important?
Sealing is important, but that definition varies agency to agency. So seal can be just tape over the top of a tube or over a container. It doesn't necessarily mean that it's dated and initialed. But just making sure that the container is properly closed, the cap is on tight and tightly twisted if it's a screw top cap. Just ensuring that it is tightly enclosed is really the key there. Whether it has tape over the top, it doesn't impact my testing. It could impact the interpretation depending on what happens to it. But
I understand that's not you guys' problem, but I want to just make sure that the jury understands whether or not the best practice is for that vial to be sealed. Sealed in terms of the tape on top of it.
And that's going to vary agency to agency, though. Those rules are independently created at those agencies, whether it has to be sealed or not sealed.
Okay. Well, as a forensic toxicologist, would you say that the best practice is for it to be sealed?
I would say that it's recommended. I wouldn't say it has to be the end-all be-all best practice, but it is recommended to be sealed because it helps with chain of custody. It helps answer some of those questions, but it's not necessarily required. It's recommended.
But it is recommended?
It is recommended.
And why is it recommended that a vial should be sealed?
As I just stated, it helps assert chain of custody. It helps assert that nothing has happened with that tube. It hasn't necessarily been opened since the time that that sticker or tape has been placed over the top with the in theory, some sort of date or initial on it.
Okay, I want to draw your attention. And Josh, could you tell us which exhibit this is? State's exhibit, the vial of blood. In regards to the vial of blood that goes with litigation packet NMS work order ending in, well, it's 23126889. Do you see that there?
The NMS number?
This is the NMS number for the vial of blood for 231-26889.
Yeah, I just don't see the NMS number on this.
You don't, do you?
On this stick, not from this view.
Right.
Okay.
And in regards to this, do you know, based on looking at this, where this came from?
I mean, I know from my review of all of the casework thus far, because of being involved in the case, I know that this was that Mayotte VUH Stat Feb was the name assigned to the patient when they were at Vanderbilt.
And you see that there's a collection date there of, can you see it from?
Yes, I can. Yes.
Collection date of 2/25/23. Do you see that?
I do see that.
Okay. And prior to it getting to NMS, you don't know where that vial of blood was, do you?
Correct.
You don't know who drew the blood?
Correct.
You just rely on whatever sticker is placed on it. Isn't that true?
Initially, we rely on the requisition form, and we match the information from the requisition form to any stickers or information provided on the tube to verify that they go with the same case.
But in regards to the individual who drew that blood and put the sticker on there, you don't have any knowledge of that, do you?
Correct.
And so you have to rely on what's there. Isn't that true?
Correct.
I want to now draw your attention to litigation packet 23126889. That's in evidence. And it is in evidence as Exhibit 42. And I want to draw your attention to pages 25 through 27 of that litigation packet. And I have a copy here for you.
Sheets, yeah.
Okay. information on here.
Yes.
And when it comes to whether or not this vial of blood was sealed, what is the answer that NMS states here?
Upon arrival, it was not sealed.
Okay. And so that would not be the best practice according to your prior testimony, isn't that true?
It's going to vary agency to agency. So if that agency's policy is not to seal it, then this would be fully fitting in with that agency's policies and procedures.
And then as we go further along to the other portion of the sample, when it comes to being sealed, what does it say?
No sample seal.
Okay.
She has very sharp nails.
And if there's been testimony that
At what point do they become claws?
no one who knows who drew that blood did not know where it was prior to getting to the ME's office, would you say that that is reliable and credible in regards to who this vial of blood belongs to?
Objection, Your Honor. Misstating the evidence. Saying someone testified to that.
Is it in the medical record?
Objection was misstated evidence.
The vial of blood here? We don't know, Your Honor, because we don't know who pulled it.
Is who pulled it in the medical record?
Okay.
I just asked it.
Yes, it's in the medical records.
Okay.
However,
I'll sustain the objection.
Misstated.
But if-
Sustained.
we don't know, or if that person has not testified in regards to, yes, that was the blood I pulled, yes, I put the correct name on there, would you as a forensic toxicologist who keeps accreditations and ensures that chain of custody and those types of things are important, would you think that that is reliable and credible to rely on?
It's not going to impact my testing.
Sure. I'm just
It may impact the interpretation, but it's not going to impact my ability to test that sample and produce accurate and reliable toxicology results. So I think your question is asking more about interpretation, and yes, it could impact the interpretation. I would have to say it's possible something may have happened to it. I don't know, that's beyond my control, but it doesn't impact my ability to test that sample.
Right, and I didn't ask about the ability to test it, just whether or not as a forensic toxicologist that would have been the best practice to maintain the chain of custody as well as making sure that it's sealed. That's all I'm asking.
Objection, Your Honor. The chain of custody was maintained.
Yeah. No, it was not. And so I just want to ask the witness the question.
You won't argue back and forth.
So,
Sustain the
fair enough, Your
objection.
Honor. In regards to the testing of litigation packet 889, you, in fact, at some point signed off on that, did you not?
I did.
Okay. You weren't the one, though, would you agree with me, who actually performed the testing?
Correct.
Can you tell us what is required in the actual testing of that vial of blood from 889?
Do you have the report that I could refer to?
I can. I want to give you, specifically I'll draw your attention to page 37 of that same litigation packet. Would the procedures here be an example of what has to be done when you are testing a vial of blood?
So this is a summary of what you have shown. This is a summary specifically of the cocaine testing that was performed, and it's highlighting the major steps in our computer system that are signed off on. So for each attempt at testing on that sample, there's a preparation step. That's the person that prepares that sample physically, loads it onto the instrument. There's an analytical step. So that's the person who's actually reviewing that data initially as it comes off of the instrument to ensure that the run is proceeding as expected. The controls are performing as expected. The run is acceptable. And then there is a final review step. It has the abbreviation BREV there. So that is a secondary technical review by another authorized analyst who also went back and reviewed that data and ensured the accuracy of the result in the run.
Okay. And then I want to take you a little further down where it says lab ID test. Now, is that more testing on that same vial of blood, or is this a different test?
It's a different test. You can see in that gray band there, the test name was designer opioids. So that first block was for cocaine testing. The second block is a designer opioids test.
And just so that we are aware, fentanyl is not a designer opioid that would be tested for. Is that correct?
It was not included in the scope of that specific test.
Okay. So you weren't testing for fentanyl here on either one of these, correct?
Not the physical lone fentanyl compound. This designer opioids panel includes what we call fentanyl analogs. So they're related to fentanyl, but they're not physical fentanyl. They are separate drugs entirely.
Correct. And then I'll take you down to where it says liver tissue. Here, that's another test that was performed as a result of the litigation packet 889, correct?
Yes, just to be clear though, this first band where it says tissue requires homogenization, this is a process step. So we can't physically test a piece of tissue. We can't put that on an instrument. It would clog up the instrument. We need to create a format for it so that it's liquid and can actually be put onto an instrument. So homogenization is just the kind of fancy term for saying that it was blended. We usually add some liquid or buffer, water buffer, and homogenize it and create it in a format that is more liquid and is more easily and readily available to go onto the instrument.
And it is a process and a step in the series of testing this liver, correct?
Correct, and that's why you see, if you go down below that very final gray line down there, when we do that homogenization, we actually create a new container and a new ID because we didn't use the full liver tissue that was submitted. We only cut a portion of it to create a homogenized sample.
And so all of those things are required in order to reach a result for that vial of blood and that liver tissue, correct?
For this case, yes.
And then after that, once you guys complete those entire processes, everything that was done, every test, every run, all of that is created in a litigation packet. All of it is documented in a litigation packet is formed, right?
Yes.
Now, when you signed your name to this toxicology report, you didn't do this particular testing, did you?
Correct.
You then relied on the individuals who did the testing in regards to what they purported their testing, the results of the testing that they performed.
They're not reporting it. I'm looking at the data generated out of the instrument. I mean, so they aren't reporting it to me. I'm physically looking at the data myself and ensuring that I agree with the result that's on that data page.
So who reports the data?
I report the final data. I create that final report.
And you have to create that final report based on the testing of those individuals, correct?
Yes.
And those individuals would be the individuals whose names are here.
Yes.
Paulina Lapp, Stacy DeJoseph, Kyle Miller, Amanda Cook, Rebecca Turner, and Tammy Welch in regards to the vial of blood, correct?
Yes.
And you rely on what they did in order for you to interpret their data.
Yes.
This is getting painful.
What all do you have to do in order to interpret that data to then sign your name and co-sign on whatever results they find?
Are you asking specifically? What are you asking me to explain there?
Before you sign your name to that report, what do you have to do? What process do you go through?
So I review all of the paperwork for the case. I look at the case results and the case data. I also look at, there's a summary sheet that comes up for each run that's performed. It's a summary that the analysts write up as a result of each batch. So say a control issue happened, they will note that on there. So I can review the control samples if I see an issue and I want to investigate it. I look at the chain of custody. I look at the login verification form, that form that said whether the sample was sealed or not. I also look at the posting history form, which is that form she just showed you where it lists the names of the analysts. So if I saw an issue in any of the data I was looking at, I can go back and physically talk to that analyst. I can email them or message them. If I see an issue on any of the runs, I have the autonomy to investigate. I can ask that a test be reperformed. If I don't agree with a result or I'm questioning a result, I have that autonomy just from doing the review of the sample. And then I also look at the requisition forms that's received. So I look to see what the agency requested, what testing. I ensure that all of that testing was performed, and all the pieces of those tests are performed. Or if they couldn't be performed, I understand why. If something needed to be canceled, if there was an interferent, things of that nature. In addition to that, I also look at phone log notes. And our phone log communication notes are notes provided by our client services. So if the client called in, added on testing, if something needed to be verified on the requisition form, if there was a typo or a misspelling that we caught during our process, it should be indicated there if the client was contacted about it. And so I'm checking all of those pieces to make sure things are accurate so that my report is accurate to the information we were provided.
And about how long would you say that process takes?
It varies depending on how much testing was performed on a case. It really does.
And in regards to litigation packet 231268889, about how long would you say that process took for you to review all of that data, adopt it, and then sign your name to it?
We had discussed this previously in previous meetings. Based on timestamps, it looked to be an hour or just under an hour, but I do question whether the timestamp on the note requesting that I review the case is an accurate portrayal of when I was first asked to review the case. It had been discussed that I may have to review this case previously, so I had been looking at the case and the case data prior to the official request coming through. So I'm not clear exactly how long it took me. It may have been less than an hour, only because I had previous experience with the case.
And so in this case, the litigation packet was 1,912 pages, correct?
The full litigation packet, that's yes, what you had relayed.
Okay. And I've taken the liberty to print it out, and I have it right there on my table. That's about the litigation, that's the 1,912 pages.
Okay.
Right? Okay. And you reviewed all of that and all the processes that you just described in under an hour.
No, I said I reviewed the case data and the batch review sheets. So by the point it reaches me, the case has undergone numerous levels of review at each test step. So my piece of the puzzle is that final review, pulling all of those pieces together. Each individual test has been reviewed and signed off on at that test level, and then it reaches myself. And so I'm performing an overview review, looking at the individual case data, ensuring that each of the batches, if there were issues or if I needed to investigate, I looked into them, but that all of those pieces for that individual case are matching up. Your litigation packet is going to include a lot of extra information, including all of the data for the quality controls that were run, the full list of cases that were on each batch, along with the case in question. So that is partly why my review takes less time. I'm focusing just on a single case, not the full batches each time.
Then it will require you to rely on summaries done by the individuals who actually perform the testing.
Right, and as part of accreditation, if any issues come up, those analysts are authorized and competent and trained in each of their individual tests, and they have to follow those standard operating procedures. So they would physically have to note that something happened, or that something went awry, or that they saw an area of concern, and then it had to be vetted and evaluated, or the proper step followed. So say a quality control failed, they would follow the standard operating procedure, which may be to re-inject the sample, it may be to repeat the whole test. It varies depending on what the issue is, but they're following their standard operating procedures, they're following their training.
I need to blow this up, and I don't want to hit a button I shouldn't hit. So.
Attorney Letitia is trying to poke holes, but I think the effect is just reinforcing the professionalism of all the people who tested these.
Here in this litigation packet is your number 231268889. That in preparation for trial on March 12th of 2026, there was an email received from Eric Evans providing a subpoena for MMR to appear the week of 6/22/26. Who is MMR?
She was the original reviewer for the case.
Okay. And we see then that on March 19th, which would be about 7 days later, there was an email received from ADA Jan Norman asking that the case be placed in the queue for KYM for review. Who is KYM?
KYM is my computer initials,
Okay.
for using our computer system.
Okay, so that's you.
That is me, yes.
And then we see on 3/20 that there was an updated report signed by KYM, which is you, and a current CV provided to ADA Norman, correct?
Correct.
And then if we look at, I'm sorry, can you notate the time on March 19th that the email from Ms. Norman came through, from ADA Norman came through?
That's when this was recorded in this communication log. I don't know when the actual email was received from ADA Norman.
Okay.
It may have been earlier in the day.
Okay. So what time do we have there?
The time on this communication log says 2:02 p.m. So that's when it was entered onto this communication log.
And here is your report and work order for 231268889. That is your signature, correct?
That is my signature, yes.
Adopting the findings in litigation packet 231268889, correct?
Correct.
And what time is that there?
14:55.
And that's military time, which would equate to 2:55.
Correct.
So between the time that it's documented on this email at 2:02, we're talking about 53 minutes.
Again, the communication log that was noted at 2:02 p.m. I don't know physically when ADA Norman sent the email and client services received it. It's possible they received it earlier in the day and they notified me that this was coming down the pipeline, and I may have been reviewing it earlier. That just may be the time that they physically documented it in the communication log. We document things in the communication log when we're able to. I sometimes, it's a couple hours after I have a phone call with someone. It's not necessarily right at the moment that call occurs.
But there's no documentation to anything like that here, is it?
They're documenting appropriately that they received communication.
And if you look up, it documents 114 to discuss timelines. Received email from Tracy Houston. It doesn't give another date, does it?
Another date for what?
Different than the date that's on the side here of 120, in this instance, 123:26.
It occurred that day. It may not have occurred simultaneously at that time.
I now want to draw your attention to litigation packet 230-86183.
She's trying to point out that some of these timestamps would make it
You also-
difficult to do the work that was recorded
We're not the
in
analyst
that
who
time
reviewed
period.
this test originally, are you?
No, I'm not.
And this, just so that we're clear, is a test of the antemortem blood of Ms. J. Benning that was taken on 2/27/23 at 2:17. Do you see that?
I do.
And again, you were not the analyst who originally performed this testing, were you?
I didn't perform the testing, and I was not the original reviewer.
And if we look at the date and time that you adopted this particular testing procedures, it was the same day at the same time of 2:55, correct?
Yep.
And are you familiar with how many pages of litigation packet is this particular testing?
It was even more. There was more testing involved with this case.
Over 2,600 pages, correct?
I'm not sure the total value that was in your packet, but there was a lot more testing to review for this one, yes.
And would you trust me if I tell you it was 2,616 pages?
It would not surprise me.
And so, from the time that you were asked to be assigned to these cases, within 52 minutes, based on the documentation, and we have to go by the documentation according to the accreditation, you reviewed all of that data, 2,600 pages in one, 1,900 pages in another, in 52 minutes.
Again, I reviewed the case-specific data, which is significantly less than the 2,600 pages and the 1,900 pages. I reviewed the specific data generated to the case. And I was aware of these cases. We have been working with both of you individually since, this has been going for more than a year. So I have reviewed these cases in the past. The reason for both of them having the same stamp time for my release is because I put them on a batch together, and I released the batch at 14:55. So that's why it looks like they both have the same stamp. I was reviewing both cases. I leave them to the side, and when I finished reviewing both cases, I click a signature button in our computer system, and it releases both cases together off of that batch at the same time. So that may help explain why they have the same release time.
And we basically, though, we have to rely on the data that's in the paperwork, right?
It's
yes or no, ma'am?
It's a communication note, noted by someone else, not myself.
And there's no communication notes whatsoever that you reviewed this document in or paperwork in or testing at any other time. There's no documentation of that anywhere, is it?
I mean, other than the communication note that we've been discussing these cases, I don't believe there's anything specifically noted, no.
I now want to draw your attention to the testing of the comforter. And that work order is 23129285. And I believe it's in evidence. Do you have that? Exhibit number 9285, last four digits 9285. Just so that the record is clear what we're referring to. This is exhibit
46 is her report on that.
Yes, this is exhibit 46. And this is the comforter that we've been talking about, correct?
Yes.
And the testing that you performed on that comforter, there was some talk yesterday about numbers and concentration levels and things of that nature. You can't quantify anything in regards to any concentrations or anything like that as it pertains to the results on this comforter. Is that correct?
Quantitation should not be done, no.
And so anything that was said to the jury about how much was found of BZE and or cocaine, none of that should be considered, because that's not what the purpose of the test was. And you guys don't do that in regards to this type of testing. Is that correct?
I would say it's fair to say that we needed to repeat the testing under dilution to ensure the accuracy of the result, but to rely on a specific number would be inaccurate. So the testing was repeated on dilution to ensure that all of our acceptability criteria was met for the data. When we ran it undiluted, some of the acceptance criteria was not met, which is why we had to repeat the test. But to rely on a specific number, I would not rely on a specific number from that, the values generated there. It was really to prove that the presence of the drug and that the results were accurate, there were no interferences going on, and that our acceptability criteria was met in order to confirm that it was positive.
Okay, I just wanted to clear that up, for the jury. Thank you. Again, we talked about labeling and doing things like that. I want to draw your attention now to the labeling for the washcloth. Do you remember testifying yesterday about the washcloth?
Yes.
Okay. And do you see the date there that it says, date and time, that this washcloth was received by Metro Nashville Police Department?
Objection, Your Honor, there's been testimony specific to this.
It's an item in evidence, Your Honor, that she can testify to.
Okay, there was testimony about why that's there. If you want to re-ask her, that's fine.
What is the date and time that you have that Metro Nashville Police Department received this washcloth?
I mean, so the label states February 25th, 2023 at 9:30 p.m.
Were you aware that Mr. Taylor did not call 911 until February 25th, 2023, at 9:38 p.m.?
The exact time I don't believe I was aware of.
I want to now draw your attention to the packaging for the comforter that we talked about. Do you see the time that it was received there? Can you read that for the jury?
The label states February 25th, 2023 at 9:30 p.m.
How important is it to document accurate times and dates and things of that nature?
I mean, it is as accurate as we can be. We try to maintain contemporaneous notes and labels with things, so it's important.
It's very important.
Yes.
To maintain the integrity of the vials and the samples that you're testing, correct?
It is important.
In regards to the test that you performed on the comforter, there was no standard procedures at NMS for you to follow with the preparation
here we go again.
of the matrix to be tested. Because I understand you guys have standard procedures for the testing. But in order to extract the matrix, there was no standard procedures, were there?
There is a standard operating procedure called forensic investigations, but due to the very nature of these, we don't know what material we're receiving. It's not specific to an item, like an item of clothing or a metal item or a wood item. Every one of these cases is very unique and different, but there is a general standard operating procedure dictating that we need to provide controls. We need to assess the sample. We need to try and take pictures when possible to document what we're seeing, what we're doing. Typically we try to perform the extraction with methanol. But depending on the nature of the case, we do have autonomy to try and do the extraction with other chemicals if we believe the methanol may not work appropriately. It is a standard operating procedure, but it allows a lot of flexibility for the toxicologist performing it to use it as needed to the case at hand, because these are so rare and so unique and so individual to the case.
In fact, I think that you classified this as a unique case of something you had to create, correct?
It is unique. I hand wrote all my notes as I was following that standard operating procedure to dictate specifically what I was doing for this case at this time. So you are showing some of my handwritten notes that I was taking contemporaneously while I was in the laboratory performing this.
But you'll agree with me, this is not something that's ordinarily done, is it?
It is not commonly performed. Our laboratory only does a handful of these, only maybe a couple a year. So it is very uniquely done.
And there are no peer reviews or any type of audits in regards to this particular testing that you created, is there?
I mean, so once I extract the biological fluid off of the sample, those samples are run under the normal test methods of the laboratory. Same type of testing as a blood or a urine sample. Really the extra handling part is me extracting that biological fluid off of in this case, the comforter. In other cases, we've had clothing, we've had metal, we've had various items received at the laboratory, even bone testing, things of that nature. So it is going through a validated test method, and then me running these extra control samples are ensuring the acceptability of the extraction method, proving that I have successfully extracted drugs from that item of clothing at the same time.
However, you'll agree with me that extracting the very matrix that you're testing is one of the most important parts, right?
It's very important. We need to be able to separate the drugs from the matrix.
Exactly, and so that is the part that has not been peer reviewed.
I disagree.
Okay. This has been peer reviewed prior to you doing it by someone?
I'm not understanding your definition of peer reviewed.
As anyone, well, let me back up. When you are accredited, there has to be reviews by your peers that what you are performing is up to the proper standard. Is that right?
Correct, yeah.
Okay, and so that's what I'm asking. That hasn't been done in regard to the extraction of the matrix from this comforter. No one peer reviewed it prior to you doing it.
Right. The acceptability of the controls run in parallel proves that this worked correctly. That is the review process there. The controls run in parallel at the same time as the case sample are proving the acceptability of this method.
I understand, but that wasn't my question. It hasn't been peer reviewed by anyone prior to you doing it.
But that would be true of all cases and samples then in an extraction by your definition of peer review. If a blood test is run, there's no one peer reviewing that blood test at that exact time. We run those control samples in parallel, and that helps ensure the accuracy of the run, the accuracy of the result, the accuracy of the extraction.
Dr. Methune, you're not saying that every other process at NMS, when you are reviewing that vial of blood, has not been peer reviewed. You're not saying that.
No, I'm not. That's why I'm saying your definition of peer reviewed is misleading. We have published on this process. There are other similar processes in toxicology that use very similar methods, something called dried blood spots. So it's blood that's dried onto a piece of thick cardstock paper, and then they will punch out those pieces of blood-soaked paper, release the blood and the drugs from that paper, and test that. That is a common toxicology test performed. It's also similar to things like sweat patches. So it's a similar technique used in a lot of other toxicology testing. And there are controls run in parallel there as well. And it's the accuracy of those controls that proves that the extraction process worked, the testing is working, that if drugs are present, I am able to pull those drugs out of that paper or fabric or whatever the matrix might be at that point.
Letitia is going to write this
accurate toxicology testing.
peer-reviewed
Let me
horse
use a better term.
right
How
out of the
about
court.
validated? Has it been validated?
Yes.
Yes or no, Dr. McDonough? Has it been validated?
What is it?
The testing procedure that you created to test that comforter, has
Yes.
it been validated prior to you creating it?
The test method is validated. It's the same test methods used in the laboratory.
Who validated it? If you just created it for this particular comforter, then who validated it?
I didn't create the test method. The test method is the instrument method and that process.
I'm speaking about the extraction of the very matrix from that comforter. I understand that once you test it, that's a validated peer-reviewed process. That's not what I'm referring to. I'm referring to the method you created to pull the matrix from the comforter. Has that been validated prior to you doing it?
I'm not sure how to answer that question. It is the controls in parallel are proving it's working. We don't validate individually an extraction method. The extraction is usually part of the test method and procedure as a whole. So running those parallel controls and then running it on the validated test method, something that was developed in the laboratory and has run thousands and thousands of samples and worked accurately, that part has been validated, but as far as I know, we don't typically validate just an extraction portion of a procedure.
Okay. In regards to this particular test, and to that point, there were several things that were found on this comforter originally, wasn't there?
So we're getting to the fentanyl in the
Are you
corner.
referring to the pink kind of solid particles?
No.
Oh.
I'm specifically referring to
The fentanyl in the corner.
the fentanyl
There
that
we
was
go.
found, correct?
You're referring to the findings, yes.
And the cocaine? Correct?
Yes. Yes.
And the BZE, correct?
Yes.
But there were other things that were originally found as well, wasn't there?
You're going to have to reference that for me.
Do you remember receiving information in regards to some of the findings that was originally found on this comforter?
Yes, I was made aware. So there was an immunoassay screen performed originally, and it was a basic panel screen. So it looked for multiple drug classes. We discussed immunoassays yesterday, and they have some limitations involved. But I received information that on top of the cocaine and metabolites and then the fentanyl, we had some indications of positive results on both the methamphetamine plate and the cannabinoids plate. And I was asked if I wanted to pursue those findings. However, I did not spike the samples for the methamphetamine and the cannabinoids, so I can't trust the accuracy of that result. I don't have controls run in parallel at that time that can ensure me I am properly detecting cannabinoids and methamphetamine. It could be an interference from the fabric. It could be an interference from one of the buffers used. I just don't have something that can help me definitively separate out those results accurately. And I didn't have approval from the agency at that time to pursue cannabinoids or methamphetamine.
Why don't you have other controls to perform the further testing?
I wasn't asked to. We specifically follow what we were asked and requested to do, and in this case, the very specific notes made from the agency were asking us to pursue the cocaine and the fentanyl.
Okay, but prior to that, you stated I didn't have, notwithstanding them asking you to further test it, you just stated I didn't have the controls in order to do proper testing because the spikes weren't in. Why didn't you have those controls?
I didn't spike a low control sample and a high control sample with cannabinoids or methamphetamine. I only spiked them with the two drugs being asked for.
Okay. And so that's why you didn't have the controls?
Correct.
Okay. And so, but you did, at some point, this testing showed up that it was cannabinoids as well as methamphetamine on this very same comforter.
There were indications of it, but immunoassays are prone to false positives and false negatives. So without having proper controls there, you really can't make any determination on what those results mean.
And you just stated that you did not have approval from the agency to further test whether or not these findings were in fact true. Is that what you just stated?
Correct, because there is cost involved with all of these tests. I didn't spike with those samples, so in order for me to pursue that type of testing, I would have had to go back and create entirely new samples and basically repeat this test all over again, and so there are costs involved that the agency would have to approve.
Who was the agency, or what agency was it?
This was submitted through Metro Nashville.
The police department?
The police department.
And so, given that this was in fact a case where there was an investigation into a possible drug poisoning or drug overdose, did anyone from Metro Nashville Police Department reach out and say, hey, we need to know if these substances are in fact on this comforter because we want to know the truth? Did anybody reach out and ask you to go ahead and perform that test?
No, and also to be fair, I don't recall us having a conversation with them about the uncertainty of those results. When I went back and looked at the data, cannabinoids was positive in every single sample, including my external lab control, which indicates that it's likely due to something in the run, like the buffer that we once I extract, I reconstitute, it's called. I reconstituted the samples in a buffer. Something like that could be at play there, causing an interference with that screen. So I really was uncomfortable trusting anything with those results, knowing that it was likely some sort of an interferent. I did go back after our conversation and look to see if I ever had any sort of a communication with Metro Nashville, or if anyone in client services had one about these results. We could not locate that we had ever notified them or had a conversation with them about them. So they didn't ask me to pursue it, but they also, I don't believe, were notified that that was the case.
Were they ever notified that that was the case?
I don't believe so. I can't find any record that we had that conversation.
And so then, in a case as serious as this, no one looked further to ensure that that was either true or not true?
Not that I'm aware of. We were asked to focus on the cocaine and the fentanyl, and that is what we focused on.
Methamphetamines, that is a type of controlled substance as well, is it not?
There are rare prescriptions for it. They do exist, but typically it is an illicit substance.
And it would be in a Schedule II drug?
Oh, I'm not sure what it's scheduled as. Scheduling changes quite often. I try not to memorize them.
You're a forensic toxicologist who tests substances, and you try not to remember the schedules of the drugs you're testing?
I don't memorize them because they can vary by state sometimes as to how it's being applied. So I do not memorize the exact scheduling of the drugs because they do sometimes change as well. The FDA changes, or the Controlled Substances Act can change them from time to time. So I prefer to look them up when asked than to rely on memory for things like that.
Do you remember what schedule cocaine is in?
Off the top of my head, no.
Now, in regards to the comforter, there were other things that were found as well, wasn't there?
You're asking about the findings.
Yes, ma'am, the findings. There was a test for cocaethylene, wasn't it?
On the comforter?
Yes, ma'am.
It may have been included in the scope of that test.
Okay.
I believe so.
And just so that we're clear, we're talking about the vomit that was found on the comforter at Jay Benny's apartment. That's what we're testing, right? On litigation packet 23129285.
Okay.
No, I'm asking. I want to make sure that's what we're testing, the vomit.
Yeah, so I'm looking. It looks like the samples are listed here. There's one labeled SD, and then at the end of it, it says G1 1 plus 99, and then there's G1 1 plus 9. So those are the dilutions.
Okay. So if we look at, let me orient you. A better way. This is going to be, I'm sorry, page 789 of the litigation packet. Do you see that 007?
Yes.
And just so that we are clear, .007 is the case sample. Do you see that?
Yes.
And the case sample will be the exact piece of fabric created with the vomitus on it, correct?
Yes.
There is a presence of cocaethylene, albeit it's not above the reporting limit, but it is present, correct?
Can you scroll to the right so I can see if the ion ratio is in?
It was in.
It was in, okay.
Okay. So, that means the presence of cocaethylene was there, wasn't it?
There are indications, yes.
But that wasn't reported in or told, was it? On your findings?
It was under the detection limit.
State that cocaethylene was present, albeit it was under the detection limit. But just so that we have a clear picture of what's going on. Wouldn't that be important?
But that would go against reporting standards.
There was also another finding.
This attorney is letting us know with every question that she doesn't know exactly what she's talking about. She can say the words and point to the reports, but her knowledge just is not there. So this witness is eating her lunch.
This is for fentanyl, isn't it?
Yes, that's the fentanyl quant.
And you see where I've marked there. There was also a finding of fentanyl in the vomitus, correct?
Based on how low this is, I would want to look at the chromatography there and ensure it wasn't noise. That's very low.
But it was present, based on these findings here, right?
There is some activity in that window, but I would want to look at the chromatography to ensure that it was an accurate peak shape and that it looked consistent with kind of an accurate fentanyl response.
But if we looked at these findings, these reportings, it's present, isn't it? It's below the limit, but it's there.
Without looking at that chromatography, I don't want to make that statement because you can have noise in that window. You can have peaks and background noise in there, which will give you some of these low lingering values. So that is where we have multiple pieces of criteria for accepting a result.
So if this wasn't noise there, then it would, according to these numbers, it would be present.
There may be some indications of it there, yes. If the peak was acceptable, it looked visually acceptable.
Okay. And if it was, then not only if it wasn't, we'll verify that. There would not only be cocaethylene present in the vomitus, it would also be fentanyl.
Based on the totality of the case, I would say it potentially means presence of fentanyl across that comforter, just because we know that there was a fentanyl presence in that negative control located other places on the comforter. I can't necessarily state that it was in the vomitus itself.
And in fact, you're right. In another spot on that same comforter, in another place, you found fentanyl.
Yes.
And this was before Ms. Benning ever went to Vanderbilt, correct?
I have no idea when the comforter was collected.
Now, I want to now draw your attention to NMS work order 230-78883. If you look at the original report for litigation packet 230-7883, what is that representing in terms of the matrix here?
This is a urine matrix.
What's the date on the collection of that urine matrix?
It was provided to us as February 25th, 2023 at 22:59.
However, there was in fact another report generated
You said that part already.
just some 10 days before trial started. Do you see that?
Yes.
And labeled corrected report. Do you see that?
Yes.
And in this report, dated 3/22/23, there was in fact a finding of fentanyl, correct?
Yes.
And this would have been in the blood of, in the urine of Jay Benning on 2/25/23 at 10:59 p.m., correct? According to this report.
The results didn't change. The only change to the report is the collection date and time. Correct.
Right. Because 10 days before we started trial, you issued another report that's your signature, correct?
It is my signature, yes.
On June 9th, 26th. And you issued another report with a whole nother day, correct?
This was based on the request of the DA's office. They had information stating that the original time provided on the requisition form was incorrect and had asked us to correct it to make the report accurate.
Now, a common practice in medical records and forensic toxicology and things like that is to not change dates and times and things of that nature, isn't it?
If changes are made, it should be noted or highlighted what the change is, but it does happen sometimes. Sometimes the name provided to us is misspelled or the wrong name's provided. Sometimes the requisition form is provided with an incorrect date or time. It happens a lot, especially in driving under the influence investigations. So we do get asked to do corrected reports with demographic information.
And I want to draw your attention to litigation packet 230-86183. And that is the report that we talked about earlier, where you issued a new report as the new analyst simultaneously with the report ending in 889. You remember us talking about that earlier?
I do.
Now, the original date on this report is March 17th of 2023. You see that?
I do see it.
And there was a report issued prior to that on March 13th of 2013.
Yes, there was. It was a preliminary report, so testing had not completed.
Okay, so the 313 was the preliminary report, and then the final report would have been 317 of 23. Is that right?
Correct.
And you weren't the original analyst there, as we discussed.
I was not. Yes, I was not on the original reports.
And then you issued the corrected report on that one. Is that right?
Corrected in this case is my signature.
Yes.
Yes.
Oh, in this, okay. So the only thing that was corrected was your signature in that report?
That was the only difference noted for that one, yes.
Okay. Now I want to draw your attention to, let me find it. Litigation packet 231-57452. Do you see the original date on this report?
So the original date would have been June 8th, 2023, and then the supplemental report was issued June 21st, 2023.
Okay. And let's, so that the jury is aware, there is fentanyl present in this report as well, correct?
So to clarify, this is the same urine sample from the report that had the corrected time. The difference here is that the original urine came in through Vanderbilt and came in as a clinical sample. During the course of the investigation, it was asked that the sample be transferred to the ownership of the Metro Nashville Police Department. And so when that happened, a new work order was assigned to that exact same sample. It's the same urine sample. And it was then entered in under Metro Nashville with additional testing added.
Okay. And the additional testing would have been the testing for the fentanyl?
You can see the 3 tests there. We were asked to test for cocaine, designer opioids, and fentanyl.
Okay. And that's the report for June 21st, right?
There was a original request.
You're speaking of this one, right?
Yes, on June 8th, and then the supplemental is the one on the 21st. So the supplemental, they asked us to do an additional test. And so supplemental refers to additional testing was performed.
Sure. And on June 8th, there was the presence of 4-ANPP, correct?
Correct.
And 4-ANPP is commonly known as an illicit form of fentanyl, isn't it?
That's misleading. It can be a natural metabolite of medical grade fentanyl. It can also be a manufacturing ingredient in the making of illicit fentanyl. It's the same drug either way. It's chemically very similar to fentanyl. So it can be present both as a metabolite or as some sort of a precursor material for fentanyl.
However, if it was a medical grade of fentanyl, we would expect to see norfentanyl as well, wouldn't we?
That was not included in the scope of the test that this 4-ANPP came from.
Well, then let's take a look at the 621. Because they did ask you to test for norfentanyl, didn't they?
Yes.
Okay. And that's where you see it here, right?
Yes.
Okay. But we still see 4-ANPP.
So the original results from the report on June 8th are still on there. And then you see the new results from the additional test asked for.
And if we look at the collection of this urine from Ms. Benning, what is the date? Let's start here on the report of June 8th of 2023.
So it was the date provided originally from the original submission from Vanderbilt. It was dated as February 25th, 2023 at 22:59.
And then on June 21st report, what is the date of the urine that was collected?
It's still the same date, February 25th, 2023 at 22:59.
And we talked earlier that you rely on whatever the matrix or the vial that is sent to you and the sticker that's placed there by the agency that sent it to you, correct?
To fill out this portion of the report?
Yes.
This is based on the requisition form. But if you see there's a note underneath with the status of the urine, it said it was thin and brown with a chunk. We also noted that there was some additional label sticker on that urine container. And this is something we do with forensic reports.
Now, let's talk about that. A brown chunk within urine. Urine is not commonly chunky, is it?
Not commonly, but you can see a wide variety of things in urine if you do enough urine testing. It can be different colors. It can have infectious colonies in it. If someone has an infection, there can be some pretty strange and unusual things in there.
But it also could be because it wasn't stored properly, and as a result, a buildup of bacteria or something formed within it as well, correct?
That's what I mean by colonies. There could be something in there, yes.
And then that would yield it questionable about whether or not we should even be relying on these tests, right?
How so?
If something is formed and created inside of the very matrix that we're testing and we're relying on something as important as this, bacteria shouldn't grow to the point that it becomes clunky, should it?
These are forensic cases at this point, and so they're a once-in-a-lifetime sample. So we get samples in a lot of different forms of decay, and it's the only samples we have available to test. So it impacts the interpretation of the results, but it doesn't impact our ability to physically test that sample, if that makes sense.
It does. However, the first time that urine was tested, there was no notation that a chunk was present, was there?
That is not part of the process for accessioning and inventorying a clinical sample. So it's possible it was there, it's just not part of that standard process. Clinical samples are treated differently than forensic samples. They undergo a different process.
I'm speaking about when it was originally tested with NMS.
Correct.
That urine was tested before, and there was no notation that there was a brown chunk in it.
It's not part of that. Notating something like that is not part of the inventorying and accessioning process on the clinical side.
Then why was it reported here if it's not part of the process?
Because now you've switched to forensic. You moved from Vanderbilt Hospital clinical sample, and then it was switched over, ownership, testing, responsibility there, to Metro Nashville PD, which is a forensic agency.
Okay, I'm sorry, I must have misled you as to what I was asking. I'm speaking about, for example, in litigation report 230788883, the same urine, there was no notation of a brown chunk, was there?
Correct, I believe I just answered that. This is the clinical sample. It is not part of our clinical inventorying process to make notations like that.
But you made it here.
That became a forensic agency sample at that point.
So it wasn't a forensic agency here?
Not due to the agreements with the samples and the testing ordered. We separate that accessioning process between a clinical sample and a forensic sample.
So are you stating that when Ms. Benning, when Metro Police Department sent you this blood, sent you this urine, that you didn't realize that it was for the purpose of an investigation?
Originally, no. It came through as a clinical sample and a clinical request from a hospital.
And so even though then what you're saying is that because it came from a hospital, if a brown chunk was inside of this very urine that you now had to homogenize, right? Because you stated earlier that you can't test a chunk of something. You have to homogenize it, right?
Correct.
And if you had to homogenize it, surely whether it was clinical or forensic, you would know that, wouldn't you?
The look and status of the sample on the clinical side is not noted as it is on a forensic sample. It's a different process. Clinical samples, there's a faster turnaround time. It's verifying that the unique either medical record code or whatever that patient ID code is matches what's on the tube, and then those samples are prioritized and run very quickly. They have a very quick turnaround time because usually it's a diagnostic request where medical treatment may be waiting on the results of that sample, so they are prioritized and put through very quickly. Forensic is taking your time more, documenting more, because there is that threat of possible litigation purposes down the road. So there is more documentation, and it is a different process from the clinical. It's just due to the purpose of those tests and those samples.
And so you're testifying that if someone is in the hospital and there's a doctor somewhere waiting on the results of this test, and you had to homogenize it, you had a chunk found in that urine, you're stating that you would not let that doctor know, who's going to depend on your findings in order to what type of treatment he will give this patient, that you would not inform him that there's a chunk in it and it had to be homogenized. Is that what you're saying to the jury?
If at the time that sample came in and was accessioned on the clinical side, so accessioning is when it's first entered and inventoried, if the technicians in the receiving department deemed that the sample was unsuitable for the testing requested to be performed, they would actually cancel the request and say we can't do it. So they determined at the time that sample arrived, there was enough sample in the correct format to perform the testing requested.
And no notation of a chunk was present?
It's not part of that process.
Okay. Nonetheless, notwithstanding all of that, 10 days before trial, another report was issued, corrected report, correct?
Yes.
And that same urine, the date was changed to 2/26/9/22. Is that right?
Yes.
And you weren't the original person who created or performed this test either, right?
Actually, I was the original person, but that signed both that clinical and then this subsequent one, which is why I knew that it had been transferred ownership between the hospital to Metro Nashville PD. That is why they asked me to be the reviewer for this one, so that we maintained the same person throughout that chain.
Okay, so you were the one who elected not to put the brown chunk on the report.
No, it's just not part of the process for the clinical side. It is not part of our standard operating procedure. It is not noted for clinical samples.
Okay. I want to now
Well, this jury might be sequestered over the July 4th holiday at this rate.
take you to
I can't see how the defense thinks they're gaining any ground here. This witness is running circles around them, making them look silly. And they just
in
forge
the
ahead
medical
anyway.
records for VUNC page 69 and 70. Do you see at the bottom of this page a collection of urine at 2259 for a urine drug screen? You see that?
I do.
And then you see another specimen collected, urine drug screen with ID numbers attached to it. Do you see that?
I see it.
And at the top of page 70, you also see 2259 urinalysis microscopy. You see that?
I do.
That would coincide with the original documentation on those reports as it relates to the urine that NMS received for J. Bennett, would it not?
That was the original, yes, date and time noted.
And much like that, I would take you to page 116 of the medical records. Do you see where it says addendum cocaine screen from ARUP, which is the metabolite BZE resulted from 227 at 8:23 a.m. was positive? Do you see that notation?
I do.
And that would coincide with what I will mark as Defendant's Exhibit 3 of the ARUP result and the urine here. 227. Do you see that?
I do.
Much like we just saw with.
Okay, we'll mark exhibits.
Oh,
They won't
okay.
be defense exhibits, they'll just be in numbers.
And then finally, Dr. McDermott, we were able to, let's go back to the fentanyl. And remember you stated that you wanted to look at the windows and the peaks in the windows?
Yes.
You see that?
I do. You can see, so if you look across the top of the page, the D5 is our internal standard. So those are looking appropriate. If you look at the two on the right-hand side, we look at two separate ions when we're looking here. So the first is our target ion. The second one on the right is a qualifier ion. And we do see some slight indications here. This is a nice peak shape. It looks that nice bell curve shape. But you also do see that qualifier on the backside It has a long tail on the right side, so it's not a great peak, but it does look to be a possible indication of fentanyl there. It is not background noise, it's a possible indication.
Correct. So there is a possible indication of fentanyl in the vomitus on the comforter of Ayden.
There's a possible indication from that sample swatch, yes.
Thank you, I pass.
Thank goodness. Wow. Somebody playing a piano in there? So we have one corner of the comforter that had a tiny, barely above the register level test for fentanyl, and they don't know where it came from.
Madam Clerk, I am going to need a couple of exhibits. Pass to the witness. Can we have exhibit 34 and 39?
Thank you.
Dr. Mitten, you've just been handed exhibits 34 and 39. Exhibit 34 should be the CFSRE report 00-92. And then exhibit 39 should be the NMS litigation packet that begins with a 15-page report. And I don't know if they left the post-it on the analysis requisition form.
It's still there.
And yesterday you testified to this on direct, and we kind of synced up the two NMS work orders on these two separate reports, and you said that they matched, correct?
Yes.
And then I asked you to look at the litigation paperwork so that you could verify the very specific specimen ID from Vanderbilt University Medical Center.
She's away from the mic. It's hard to hear her.
And you were able to do that, and we talked about the specific barcode and that there was a specimen ID.
Judge is going to say, what's your question?
Specific requisition form. Is that right?
Yes.
And this particular sample, that first urine at 2259, was sent to NMS, and NMS transferred it to CFSRE, correct?
Correct.
It wasn't tested at NMS. CFSRE did the testing on this particular sample.
Vanderbilt specifically called and told us not to test this sample, and specifically asked us to transfer it over to CFSRE. So the testing on it was canceled at the request of a doctor at Vanderbilt.
And yesterday we matched this up with the specific VUMC medical record with that specific specimen ID, so we know the exact time.
Yes.
And then on direct testimony, I did not ask you any questions about the NMS work order number 23078883 that then transferred to 231574552. I did not ask you any questions. We did not submit those reports. Is that correct?
I don't recall. There have been a lot of work orders. I don't believe so.
If it's not one of the exhibits, would you agree with me?
If it's not one of the exhibits, yes, I agree.
And so now I would like to ask that this witness be passed the first 6 pages of the litigation packet associated with 23078883. To the last page, which is the 6th page.
Yes.
And on this, we have a requisition form that has that same date on it, but we are missing a barcode and a specimen ID on the requisition form. Is that correct?
Correct.
Which that is the thing that allows us to tell us which specimen this is.
It helps identify it, yes.
And so I'm putting up the requisition ID from on the left of the screen. We have the sample that was sent to CFSRE that was not tested at NMS with the barcode. And then we have on the right, the one defense counsel was just asking you about. The state did not submit this testing. And we don't have a barcode, but we have the exact same date, time, and it almost looks completely identical. Is that correct?
Yes, they're very similar, yes.
And we know that this one on the left with barcode, that one is the CFSRE, that is the one with the barcode and the specimen ID that matches the medical records. And that is what Dr. Protolewski testified to in the report that you have in your hand. It all matches up, correct?
Yes.
And this one on the right, it does not match up because it doesn't have the correct information, does it?
It doesn't have additional information.
And you were asked recently to update the report because the report had a collection time that we knew was incorrect.
Correct.
And so if anyone were to submit the NMS reports during this trial, the one thing we knew is that date and time was not right, and we did not want it reflected on the report that would go into evidence. Is that correct?
The original released reports were deemed to have the incorrect time, so yes.
Is it correct, Dr. Mintham, that we actually discussed that well in advance? It was just when we were getting close to trial, we realized the report itself had never been changed.
Yes, we've been discussing this since at least October of last year.
And part of that is why additional tests for fentanyl were run, just to ensure that that first urine and that first blood that only had cocaine in it, that everything was correct. And all the subsequent testing that has cocaine and fentanyl, that is all after medical treatment.
It was not always clear why they were adding extra testing at the time they were doing so. So now in the context and years later, having that information, it makes more sense. From my side, I only knew that they were asking us to add fentanyl at the time to verify if fentanyl was present. So in the context of time passing and understanding more of what happened here, it makes sense why more of that testing was added and why it was transferred over the way it was.
Okay, so we cleared that up. Let's go back to the comforter. You were asked a lot of questions about fentanyl on the comforter, and you said that that can be noise, and that you had kind of that noise marker in multiple places, and you would not say that it meant there was any fentanyl connected to the actual sample that tested positive for cocaine.
I think to clarify, I don't feel that the fentanyl necessarily can be stated it was from the vomit. It could be on the comforter. It could have been on the fabric or the swatch. I I can't draw a parallel and say that it was connected to the vomitus necessarily. It could be an artifact that was on the comforter because we have low levels in other locations in the absence of the cocaine.
And you said that that was a trace amount, correct?
It was a very low quantity, well below the detection limit.
And that could be from some type of external contamination.
Certainly.
And Ms. Holland spent a lot of time asking you about peer review, and I don't think we were really talking about peer review. Dr. Mithun, you actually have published on this process that you utilize to test the comforter, but actually this particular comforter and the testing that you did in this case. Is that correct?
It is one of the cases in a case series. Myself and other toxicologists with NMS who performed this type of unique testing, we did publish a paper last year. It has been, I guess, peer-reviewed or reviewed as part of the journal writing process and deemed acceptable by peers in our field.
And I would ask that the witness be passed a document, which you provided a copy of your published journal article during our discussions in preparation for trial.
Yes.
Which that was also provided to the defense counsel.
Yes.
And so the questions about your handwritten notes, that is your process. That is something that is unique because not very many people do it. Is that correct?
That's fair. Yes.
Coughing's getting bad.
And we've talked about the fact that many times that as a forensic toxicologist that you might do that re-review and create your own opinion, do the analysis again, have your own expert opinion, and then you recertify a report. But this process is very unique and specific. Is that right?
This one's very unique. I mean, it's still technically reviewed by another toxicologist who is authorized to do this type of testing. So I'm not just putting reports and results out there without other individuals looking over what I have done, the conclusions I have made, and technically reviewing them and administratively reviewing them to ensure the accuracy of that report that I put out.
And you did that particular testing. You did some other testing in this case, and we did make a request of you if you could come to be our one witness, so we wouldn't have to have a minimum of 3 people from NMS testifying about the same testing.
Correct.
And I think there's been a lot said of somehow that recently happened, but we started talking about that at the end of last year.
We did. We did. To avoid having at least 3 individuals, potentially more, coming from the laboratory, we were trying to simplify and see if one person could come instead of multiple.
And I know that I don't email you directly. Tasha is kind of our go-between. But if I have an email from December of 2025 where Tasha said, we will go ahead and start that process, is it fair to say that you might have started analyzing things a little bit earlier?
Objection leading. Okay, do you want to show her some email? Do you know?
I don't know any personal communications between her and Tasha is in our expert services department, so it's a department devoted to helping and assisting us with court and with legal proceedings. And she has been heavily involved in communicating with the DAs, so it would not surprise me, but I don't know specifically what was stated in those emails.
Which, Dr. Mithun, in all of the testing, it is consistent that there is cocaine or its metabolites only in the first blood, the first urine, as well as the testing that you did on the comforter. And it's after Ms. Benning was in the hospital that fentanyl shows up in any of the samples. And that
That is correct.
Thank you, Dr. Midland.
Any other questions?
Yes, ma'am.
Of course, Letitia gets the last word.
Just so that we're clear, there was no medical professional from Vanderbilt Medical Hospital, University Hospital, that called you and said those dates for the collection of that urine for the drug screen is wrong.
No, the request always came from the DA's office.
Thank you.
Any other questions? Thank you. What are you wanting her to do with this journal?
Be released.
Sorry, Your Honor, please. I think it can just be marked for identification. I didn't really have her go into a great detail about it.
Okay. I'll give that top document to the clerk. We'll mark it 48 for D.
All the rest of this stuff.
Let's give it to the state.
And I apologize, Judge. I thought we were just talking about the article. I would like the 6 pages entered as an exhibit.
Okay, litigation, first 6 pages, sorry, back to 49. All right, thank you, ma'am. You can step down and be excused.
Am I released or will I be recalled?
Any reason this young lady needs to remain?
No, Your Honor.
Okay. Thank you.
Released.
Thank you.
Who was the next witness, please?
Miss Johnson, Miss Michael Johnson.
Okay.
Okay, Miss Johnson first. Don't have Apple yet. This witness did a great job. I used to love those pens that the judge has. Didn't know you could still get them. It's old school.
Do you swear the testimony you're about to give to be the truth, so help you God?
I do.
Good morning, Ms. Johnson. Can you please state and spell your name for the record?
Michael Johnson, MICALJOHNSON.
And Ms. Johnson, where were you employed back in 2023?
The Tennessee Titans.
How long were you with the Tennessee Titans?
From 2020 to 2025.
And did you know Blaise Taylor?
I did.
Okay, how did you know Mr. Taylor?
He was a coworker.
Okay, here comes the T.
Was Mr. Taylor employed with the Titans back in 2020 when you started?
He was.
And what was your position with the Titans?
I started as an intern and then I was a scouting assistant.
And what was Mr. Taylor's position with the Titans?
Pro scout.
And can you explain to the jury what the difference is between a scouting assistant and a pro scout?
A scouting assistant handles more logistics, as helping shuttle players around, but they also have scouting responsibilities, scouting reports, covering players. A pro scout has more scouting, watch film, reports, those types of duties.
And do scouting assistants and pro scouts have interaction? Do you work together?
Yes, we work together on a handful of projects, and there's a lot of interaction between players. Just as things come up, we work together on a lot of things.
And about how many pro scouts were employed with the Titans back in February of 23, if you recall?
There was 2.
Okay. And who were they?
Blaise and Brandon.
And can you describe for the jury what your day looked like working with the Titans and what your hours were and things like that?
It depended on the day, but in general, we would get there around 7. You'd have breakfast, you'd get started on some reports, you might have a meeting, then you'd go out to practice if the team is in season, out to practice, come back, have lunch, get back to your desk, work on something, you could have a meeting again. Then it's dinner time. Some people work out around dinner time, and you're usually there around 8 o'clock at night, typically.
Okay, you said breakfast, lunch, and dinner. Was it typical that you ate there at the Titans facility? You did everything there?
Everything there.
Okay. Can you talk to the jury a little bit about if you could take off for appointments, who you would talk to, kind of what that looked like if you were not going to be in the office?
If you were not going to be in the office, you would typically let someone know amongst your group, but in general, you also weren't really gone. You weren't really allowed to be gone. You're expected to be there most days.
Can you talk about groups? What was your group back in February of 23?
My group, I was one of 3 scouting assistants in a shared area. Blaise was also in our area. So it was kind of that group. There was a couple other people that weren't in the room with us, but that were our age, that we crossed over a lot with work. That was kind of our group.
Can you walk us through like what the workplace looked like, where you sat, where Mr. Taylor sat, things like that?
We were in a room with 4 cubicles. My desk, I was back to back with Blaise. We were on the same side, and then there was the other 2 scouting assistants were right on the other side in this space.
And were you back to back with Mr. Taylor from 2020 to 2023, or no?
No, that began in 21.
Okay. So prior to 2021, where were you? How close in proximity were you to Mr. Taylor?
Still in close proximity, in a shared space, but instead of being back to back, he might be across the way from me or kitty corner from me, still in the same room, same space.
And did you and Mr. Taylor talk almost daily at work?
Yes.
Okay. Did you and Mr. Taylor ever hang out in group settings outside of your workplace?
Yes, in group settings.
Okay. And prior to February of 23, were there any days that you can recall that Mr. Taylor seemed different at work?
Prior to February of 23, in the fall of 22, there was a day that he was asleep at his desk, and in general seemed a little bit quieter.
Okay, I was just about to ask you about that. What was Mr. Taylor's normal demeanor at work, and how did he normally act?
Your Honor, I would object to the demeanor evidence in regards to this particular case and this witness testimony.
Okay, I'll overrule the objection. Go ahead.
Overrule?
You can answer.
I would say in general, quiet, but co-worker, easy to get along with.
And at some point, did Mr. Taylor's demeanor behavior change?
I would say the fall of 22.
Okay. And other than that time that you talked about of him falling asleep at his desk, what else, if you can recall, what were you talking about?
I noticed on his phone a bit more. There'd be times that his computer wasn't on yet and the work day had started. And we're a few hours into the day and it's not on. Things like that.
And during those 3 years that you worked with Mr. Taylor, did he discuss his personal life often?
Not often, no.
Okay. Did Mr. Taylor ever talk about having a girlfriend?
He did not.
Okay. Did you ever know of Mr. Taylor to have a girlfriend or any specific female?
There was one name that I had heard, but other than that, there wasn't any particular one person.
Okay, and did you hear that name from Mr. Taylor?
Yes.
Okay, and what was that name?
Xavier.
Okay. And any other comments about women that Mr. Taylor was dating? Anything that he was saying?
In general, it was different women, or there was a comment, you don't bring sand to the beach. Just to me seemed like different women.
You don't bring sand to the beach?
And Ms. Johnson, had you ever heard of the name Jay Benning?
No.
In taking your attention to specifically February of 23, did you know Mr. Taylor to have a steady girlfriend?
No.
And at any point, were you made aware that Mr. Taylor was expecting a baby?
No.
Does anyone
And
bring
did
sand
Mr.
to the
Taylor make any comments about being a father?
In general, the comments in casual conversation would be not ready yet, not anytime soon, things of that nature.
Now I want to take you to the week of February 27th, that Monday of 2023. Was that a big week for you all?
Yes, that was the week of the combine, NFL combine.
Okay, can you tell the jury why NFL Combine is big for the Tennessee Titans?
So it's a major college scouting event. It's a major scouting event where the coaches go, GMs go, scouts to see the upcoming draft class.
Okay, and you talk about scouts. Do you recall who was away during that week of the 27th?
The college scouts, coaches, the GM, everybody in the building. Not everyone in the building, but a majority of the staff.
Okay. Was Mr. Taylor still in Nashville?
Yes.
Okay. And had he made comments prior to the week of the 27th about that week of the 27th?
He did. He said, don't worry about coming in next week.
Okay. And how did you feel about that comment?
To me, it felt a little odd.
And why is that?
Just because he didn't have the authority to tell us when to come to work or tell us when to come, when to leave.
And had Mr. Taylor ever told you prior to that week, don't worry about coming in?
No.
Okay. Monday the 27th, do you recall that work day?
Yes, it was a regular day in the building, about 7. Just a regular going about business day.
And was Mr. Taylor at work?
He was.
Was he on time?
Yes.
Can you tell me about Mr. Taylor's demeanor the Monday of the 27th?
It was normal, nothing out of the ordinary. It just seemed like a regular day.
Was Mr. Taylor at work all day?
He was.
The next day, Tuesday the 28th, what can you tell me about that day?
That day he wasn't there, and the group of us that was still in the building, we were concerned where he was. Had anyone heard from him? And no one had. And it was until the afternoon that he was back.
You said you were concerned. Was it typical of Mr. Taylor not to come to work?
No.
And did you reach out to Mr. Taylor that day?
I personally did not.
Do you recall about what time Mr. Taylor showed up for work?
It was around 1 o'clock.
Do you remember how Mr. Taylor was acting when he came to work?
Yeah, he seemed normal. He said he had run an errand, or had an errand to run, and was just back. No need to worry.
Other than him not showing up till the afternoon, was that day normal for Mr. Taylor? Did he stay
regular, from what I remember?
And then Wednesday, Thursday, and Friday of that week, March 1st, 2nd, and 3rd, was everything else seemingly normal with Mr. Taylor?
Mm-hmm. Yes.
Can you describe his demeanor?
The same, easy to be around, person, same guy.
During that week, did Mr. Taylor ever mention Miss Benning?
No.
Did he ever mention his baby girl?
No.
Did Mr. Taylor ever seem upset that week of March 27th or February 27th to March 3rd?
He didn't.
Okay. Was March 3rd the last day Mr. Taylor was at work? That Friday?
Yes.
He did not come back March 6th, that Monday?
No.
And did you have any contact with Mr. Taylor after March 3rd, that Friday?
No.
Did you reach out to tell Mr. Taylor happy birthday?
I did.
And then after March 3rd, did the Tennessee Titans release a good player? Okay, do you recall about when that was?
Yes, it was the 10th.
March 10th?
Yes.
Okay. Were you privy to a conversation involving Mr. Taylor about that specific player?
Yes.
Okay. Can you tell the jury about what Mr. Taylor said?
He called one of the scouting assistants next to me and asked.
Objection, Your Honor, calls for hearsay unless she personally heard the conversation.
I did. I was
Was the phone call on speaker?
Yes.
Okay. Can you please tell the jury what Mr. Taylor said?
He asked if we had just released this player. It was big news for the team that day. And he answered, we said yes, it was true. And then the scouting assistant asked, "Are you okay? Where are you?" We didn't know. And he said it was fine. Everything's fine, just family stuff. And that was the end of the phone call.
And that was, do you recall if that was the 10th when you released
it was
Ben Jones?
Yes, the 10th.
And at what point did you find out that Blaise Taylor had connections with Miss Jade Benning?
When I met with the detective in August.
And was it around that same time that you found out Miss Benning and her baby girl had passed away?
Yes.
Your Honor, come with me one moment.
So he's upset about a player being released, but not bothered by Jade's passing. Is that what we get from that?
Ms. Johnson, do you see Mr. Taylor in the courtroom today?
Yes.
Okay. Could you point him out and describe something he's wearing for the court, please?
He's got the blue jacket on with the tie, gray tie.
Your Honor, if the record could reflect Ms. Johnson's identification of Mr. Taylor, please.
Okay.
And those are all my questions. Thank you.
He's the man in the blue jacket with the dark tie, sitting next to the other men in blue jackets with dark tie.
Quinones Hollins, I'll be asking just a few questions. If at any time you don't understand, let me know. Okay, I'll do my best to rephrase. Ms. Johnson, how old are you?
29.
How old would you have been around the time that you were working with Mr. Taylor?
26, 25, 26, 27.
Can you tell me what is Advance Project?
Advance?
With the Titans.
Advanced scouting.
Yes.
So you are traveling to, it's during the season, you travel to an opponent's game to get signals, and you come back, you report to the coaches on your findings, and it's all in preparation for the next week's game.
And let's talk about whether or not did you participate in Advanced
Getting
scouting?
signals, like stealing signs?
And did Mr. Taylor participate in Advanced scouting?
He did.
Were you guys' job duties pretty similar?
Yes.
Or would you say that Mr. Taylor had more responsibilities than you did?
He had more pro teams than I had to handle, but I had other picking up players, transporting them around Nashville, more of the logistics side than he had to handle.
Okay, so what did he What were his duties?
To handle the pro teams he was assigned, and then a handful of other projects, kind of depending on the point in the year that we're in, what his involvement would be.
Now, how long would you say that you worked with Mr. Taylor?
2.5 years.
What is Mr. Taylor's birthday?
March 22nd.
That's when you called in?
No, I texted.
And he was already gone from there, correct?
Yes.
But you felt that he was worth the text to text him?
Yes.
Where is he from?
Texas, I believe.
Do you know?
I do not know for sure.
And what, if anything, well, let me ask you, what's his favorite food?
That I don't know.
Who is his favorite player?
LeBron.
And where does he like to go for vacation?
That I don't know.
What is the airspeed of a small?
What school did he graduate from in terms of high school?
High school, I'm not certain.
Who was his first girlfriend?
I don't know.
What is this? Objection relevance, yeah.
Where's his father from?
I don't know.
Where's his mother from?
I don't know.
Last four of his social?
How old exactly is his sister?
I don't know.
How often did you and Mr. Taylor speak on the phone about personal things?
Never.
How many times when you had serious issues in your life did you call Mr. Taylor?
I did not.
So why, Ms. Johnson, would you expect for him to call you?
I don't.
How does Mr. Taylor deal with trauma?
I don't know.
You talked about when he came back to the office after February 25th that he just appeared normal.
I did not say after February 25th.
Well, when were you talking about when he came back and was normal?
The 27th.
27th. You stated that he was just normal. What is the name? Let me ask you, who is Dr. Sheila Peters?
She's a team psychologist.
And what is her purpose?
To be a source for the team if there are any issues. I think mental health types of psychologists help.
And that's her primary purpose for the, or at least was in 2023, correct?
Yes.
And you could have utilized her, right?
Yes.
The same way Mr. Taylor could have utilized her.
Yes.
Were you aware that he met with Dr. Peters on at least 2 occasions as a result of this incident?
No, I was not.
And if he would have met with the very person that the Titans provide for emotional and mental help, that would be consistent with someone who may have been concerned.
That is Ms. Johnson's.
Yeah, I'll sustain the objection.
How many boyfriends did you tell Mr. Taylor about?
None.
And when you were 23, were you prepared to be a mother?
I don't know.
Because you're young, right?
I don't know.
Right. And it's nothing that really you even want to think about, was it?
If someone asked me, I wanted children, so I said that.
Well, would you agree that it's someone's personal choice as to when they want to become a parent?
Certainly.
And each one of us have our own day and time that we want to become a parent. Wouldn't you agree?
No,
We don't get to choose when we want to become a parent?
not necessarily.
Who gets to choose that for us?
God.
Okay, she says. I think you have some say in
When
it.
Mr. Taylor
The
left,
final say, maybe.
how many times did you personally call him and talk with him?
I talked to him once.
You called him afterwards?
Oh, no.
Right. How many times after he left the Titans did you call and personally talk with him?
No.
And the reason you didn't do that was because you guys just weren't close like that, were you?
No, we were instructed not to talk to him if we didn't have to.
But if he was someone that you would consider a close friend to share personal information with, you would have checked on him, wouldn't you?
Yes.
But you didn't consider him a close personal friend, did you?
He was a coworker.
And you were a coworker to him, right?
Yes.
And we don't necessarily share trauma, deep personal issues with our coworkers, right?
No.
And there's nothing wrong with that, is there?
No.
Now, you stated here today that he told you not to come to work the following week.
He said, don't worry about coming in.
Okay. Do you remember testifying before about this incident?
Yes.
And in that, did you ever say that he told you don't worry about coming to work the following week?
I don't remember if I said that or not.
Would it be helpful to you if you were to review your testimony to refresh your memory?
Sure.
We're going to prove a negative here. Spoiler alert, she didn't say it. She probably wasn't asked it, but now she gets to review the entire thing while we sit here and wait. And the jury spends their Saturday spinning the wheels. The coughing is quite contagious. It's spreading around. The right answer to that question is I don't think I was asked. I don't remember being asked. That's why this argument doesn't hold a lot of weight to me. If you didn't say it before and now you're saying it, and it's something different, like a different area of questioning that they didn't ask. Jury is not sequestered. The judge has not made any indication that they're planning to do that. I just know he wants this done by July 4th. This witness has requested not to be shown on camera, and the judge obliged. I don't know the reason for that, but judge makes the rules. We moved the coffers right up to the microphone to make sure everyone can hear.
I don't see that I said that.
Right. You didn't say that before, did you?
She just answered that.
And you never said it until today, isn't that true?
I've said it before. I wasn't asked a question that made me answer that in this trial for the bond hearing.
And you didn't volunteer it either, did you?
No.
And that would have been something important when they asked you previously when you were going to testify. Wouldn't that have been something important to say if he told you don't come in the following week? The very week that's at issue?
I don't know.
Thank you. I'll pass the rules.
Questions, Your Honor. Ms. Johnson, you were asked if Mr. Taylor was worth reaching out to on that 3/22 of 2023 date for his birthday, but you had no idea about Miss Benning and his baby girl at that point, did you?
No.
And Miss Hollins asked you about how people responded to trauma. If your boyfriend was dying on a ventilator in the hospital, would you go to work?
No.
Okay, would you go to work the whole week and act normal?
No.
Those are all my questions, Your Honor.
You're a woman, correct?
Yes.
And he's a man, correct?
Yes.
Would you agree with me that men and women handle emotional things differently?
Yes.
Would you agree with me that men tend to more internalize things than women do?
It depends on the man.
Correct. It really just depends on the individual, doesn't it? Everyone doesn't respond the same, do they?
No.
And that means nothing, does it?
I don't know.
Thank you.
Any other questions?
No, sir.
Thank you. You can step there. All right, ladies and gentlemen, the jury, if you'll step down the hallway, we'll take a short break.
Would I go to work? Probably not. I don't think I would.
All right, you can have a seat. Mr. Moran, I guess you'd be the one to ask. We marked what was stuck on there, Defense Exhibit 1 as 47, which was 6889 litigation package. What did the defense think was number 2?
It was the ARUP, test laboratory toxicology report.
Okay, where is that?
So, I was told you didn't need it, so I stuck it back in.
Judge, I'm sorry, was there a request for that to be admitted?
She mentioned a couple other things, but is this,
I thought it was in the medical record.
What's that?
is this out of the medical records?
Look, I can go look and see. I don't think so, Your Honor.
I don't know who AARP is or AR.
Yeah, no, it's not. It's not.
It's not in the medical record?
No, because if it was, there would be.
He was provided to the medical record,
Right.
so it wasn't part of that.
I don't know what they're fighting
I guess
over.
I have an objection because I don't believe it's been authenticated. I don't know where it came from.
I
It's
didn't.
108.
I will need to.
Oh, okay. All right, and then what was Defense 3? You stuck a sticker on?
No, that was 2 that I stuck the sticker on.
Okay, so there's not a 3?
No, there's not.
Oh, okay, then we're straight. And who is the next witness?
The next witness is Detective Adam Reese.
Okay.
Teasing it out.
Your Honor, before I restart, I don't know if the state is intending to introduce those hinge and Tinder records. We had filed a motion a while back that we never got to, related to the hinge and Tinder records, just to put on everybody's radar. So we're not going to.
Detective Reese testified about Tinder records.
Tinder.
I am not intending to ask him specifically. Like, I'm not intending to put any of them in specifically on direct. I do have them available if it becomes relevant during his
Okay, she's
prosecution.
not going
Both the hinge or the Tinder records?
Well, I don't recall your motion, so I would like to look at it before I say more, but technically no. I mean, he might testify that he reviewed them.
Why ask him if you're not getting into it?
Oh, I'm just saying he might answer it without me
Just tell
realizing.
him you're not going to ask him about that.
Well, I mean, they did meet on Hinge, and he did review the records. I don't, what, can I get a copy of the motion so I can see what you're objecting to?
Yeah, it was part of the 90211 notice that we got with the Hinge records, so we had noted an objection to that. But also, I don't know.
I guess you would know whether you're going to want Detective Reese to introduce Hinge or Tinder records.
Right, you told me not to ask him about them.
No, I'm saying, do you know whether you were planning on trying to introduce Hinge or Tinder records?
I am not intending to introduce
Okay.
them on direct, but if they cross-examine him and it becomes relevant, then I might ask.
I get that. All right.
Thanks, Jim.
We'll cross that bridge when we get there. All right. Judge heads out the door. We get a few minutes to talk amongst ourselves, as this morning started off not the spiciest, but it has indications of going that direction, as Letitia Quiones Moanes, I don't remember her last name. Letitia has a long last name. Has been quite doggedly chasing a rabbit that she was unsuccessfully able to pursue yesterday during the voir dire portions of the court. She once again unsuccessfully chased the rabbit today. And I say unsuccessfully chased because she wanted everyone to think there was something there, and I don't think there was. There just was nothing. There was no gotcha. There was no aha. There was no mic drop. There was no, the hidden result that reveals everything and that tells all. It just didn't happen. And for all she tried to confuse and obstruct and divert the attention of the jury, the witnesses were able to clarify and also educate her as to why even her question is stupid. So we're going to continue that as we go on today. Apple is still on the schedule for today. Apple's supposed to be called today, so that could be interesting. But did you peer review? Oh my goodness. Did you have this new process you've used to extract, in this case, to extract the biological material from the comforter, peer reviewed before you did it? That was her question. And she asked it like 6 ways. Was it peer reviewed before you did it? Ma'am, let me just say, before you do it, there's nothing to review. It would be like asking a chef who just made a new dessert, a new kind of cake. Okay, he made lots of cakes before, but this is a new cake. But did you have anyone taste it before you made it? That's how stupid that question was. Voir dire was yesterday. Seems way longer. Yeah, we got through it a little quicker today. We're only about 2.5 hours into testimony today, so she gets an A+ for effort. You got to give her that. She is giving it her all. That drove me insane, says Civil Psych. That's like saying, did you get the results of your study before you conducted the study? Yeah. And were they peer reviewed before you started your study? You need to run out for a bit. They usually take lunch around 1 Central. I think it's a little later, like 1:30 to 2, somewhere in that range, and it's normally an hour long. So if that helps at all, Christy, don't want you to miss anything exciting. And it's moot because it was peer reviewed and then published as New Science. It's like you can literally read about this in the journals. This is something that other people learn from because we did it right the first time. All right. Not giving her anything either. What's scary is she only has to convince or confuse one juror. That's what I loved about these witnesses. Sometimes when you have an expert witness, they are so technical that when pressured into a corner, they revert back to the vernacular of their profession, which might be very specific, and use terminology and things that just aren't there. This witness kept it simple, and every time she was confronted with one of these twisted questions that tried to mix the testing and the procedure with the results or however it was phrased, she would turn to the jury and say that's misleading. Here's how it works. This is why it makes sense. And it was always simple to understand. She'd follow and clearly explain. Extremely collected. Didn't require the state to make any objections, just to sort of give her breathing space. The witness was entirely comfortable on the stand because she had the defense outgunned on this one for sure. Yes, but you can taste the cake better. And was it poisoned? I like she pushed back with terminology like inaccurate and misleading. Oh, she labeled it exactly what it was. Nope, you're twisting it. Nope, that's misleading. It's like she made her own objections to the question. All right. Once she even threw it back to the defense saying how so. Yeah, it's like, in what worlds is that possible? Love that witness. All right. Kathy says, I think he did it, but the state has a tough job because of the well-meaning friends. They did cause problems. And we've talked a little bit about this. I want to talk a little more because we have a break for a couple of minutes. But when police get to a crime scene, they find evidence however it was last left, however it was last touched. And sometimes that evidence might have been washed or attempted to be washed, a bloody knife found in the dishwasher with a little bit of blood, by the handle and the blade, or something like that. They find evidence that has been used, moved, contaminated with other things. They're used to that. So in this case, they have the same thing, but the evidence was sort of delayed in getting to them. That's a problem, but it doesn't quite mean that it can't come in. That they can still do testing and say, yes, this is what the results show. We just have to understand that this was outside of our control. We didn't know about it for an extra day or two, and it was in someone else's control. And they are saying this about it, but we can't be sure. So it means that the weight of the evidence probably is lessened in the eyes of the jury as to what it means, but it doesn't mean it's completely dismissible. Happy birthday, Kathy, by the way. Let's talk about the friends. Don't go in crime scenes, guys. Just don't. If you think it's a crime scene, even if the cops haven't said it's a crime scene, don't go in the crime scene. Those friends delivered mountains of reasonable doubt. Who knows what else they did? Well, they moved the camera. They bagged up the comforter and a yellow washcloth, and they traipsed around the crime scene for sure. So we know those three, maybe more. All right, I'm embarrassed how many times I've rewatched Todd Gabler's cross exam. Don't be. They closed the blinds. Oh, right, there's more. Kathy, you look great at 28. That is amazing. I don't know how you do it, but you're 28, right? And now they're evidence. But they had gloves on. The gloves they had on, they stole from the hospital. And I imagine they didn't put them on at the hospital. And if they did, then driving and being in the vehicles and everything else, that usually you put the gloves on right before you need to use them. And you don't touch anything else between putting them on and using them. And then you take them off. Having a pocket full of gloves for sterile reasons, that defeats the purpose. There's a reason they're sold in boxes. They're stolen gloves. File some charges. Stealing the gloves. Kathy. I think I do as well. Very close to that, my oldest. I don't know how old they are. Birthdays are hard for me. I can remember mine and my wife's and my daughter's and one of my sons. Other than that, that's what iPhone is for. Cops keep gloves in all kinds of places. It's true. They keep them on their belt, right? They'll take gloves and tuck them into a little holder on their belt. Yes. I don't count kids' ages. I remember my anniversary. Yes. And one of my kids' birthdays, because he was born a year and a day after we got married. So I remember that too. To be fair, Cauliflower, I think some of my kids don't remember their birthdays either. So it's all fair. All right, couple more minutes. The jury is getting a little bit of a break here on this Saturday. They've been called into court to hear testimony so we can get through the state's case in chief, which they should be finished with after 2 more witnesses. I think Apple's going to be the last one. Apple's going to be the smoking gun. And so we'll have the detective and then Apple. And then we might actually get into the defense case in chief. The judges told them to have some of their witnesses ready to start today. So, let's see. Yeah, we knew we wanted kids right away, Kathy. You can't put off those tax write-offs. You need them immediately. It's hard. Financially, starting out, young, married, the whole world ahead of you, and an empty wallet. Need the tax write-offs. Surprised they're going a full day on a weekend. The judge is really worried about this taking too long. No court on Sunday. I think Apple is going to be on the stand long enough to pretty much take us almost to the end of the day today, including cross-examination. This is my gut feel. And then maybe one defense witness today. I blame Letitia. Their defense has been very good at asking a lot of in-depth questions and some questions that don't matter. And I'm not just talking about the 20 questions game we just played with the coworker at the Tennessee Titans. Ricky C says, let's remember to hit the like button. I have to tell you, I'm super excited. Next week, I accept delivery of my my counter. We're going to have a desk counter right here. It's going to be, well, right here on my desk. And it's going to be a live counter, so when you click the like button, the counter's going to go up. And so when I'm on this view, you guys can see how many likes there are. Because a lot of times after we reach like the 1,000 point, you can't really see the actual count of likes. And this will allow you to do that. And you can also change it to, when my son's going to program this, so you can change it to show how many subscribers we have, how many likes we have, how many viewers. I think we can do both live viewers and total viewers. So we'll get that all sorted out. That's going to be an exciting addition to the desk. Hopefully it's not too noisy. Hopefully it doesn't click a lot. Click, 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 click as it rolls through. Because then we might have to move it somewhere. All right. How many days are you on holiday next week? As long as the court is, probably 2. When is, let's see, the 4th of July comes in on a Thursday. So probably Thursday and Friday, I'm guessing, are going to be holidays. We'll make the channel more interactive, and it will also, I've always loved these counters. Like this is something I've always wanted, and I thought it was a great idea for anyone's social media page. But they design them for like Instagram. It's like, hey, follow our Instagram, and if you do it, and you click the button right while you're there, you can see the number go up and see your number on the screen, and then you're done. It's like, hey, that's cool, and I can never do it again. But by changing this to be the number of likes on a video, the number of likes on the live, or something like that, number of comments on a video, I think we can do that as well. It's something that you can engage in over and over, and it makes it more fun that way. Loves True Crimes, thank you for gifting 5 memberships. Appreciate that. Most generous. Thanks, Shelly Knuckles, for the flow state. 4th is on Saturday. Oh, you're right. I was looking at this month. Okay, so probably just Friday. Can you like more than once? On each video, you can like once. RA isn't answering my question. Where was your question, Kelly? Let's see. Let me go back. How did it go with your son and the transmission issue? They had an awesome guy stop by and help them get their car, tow their car to a shop that he knew the owner personally. And said, this is a good one. This one, not going to rip you off. They can help. And then he stayed with them for an hour and a half. Well, they had family drive in on her side, come down and pick them up. It was awesome. But now they just need to figure out if they can repair the transmission in their car. They're at that point in life where it's all you can do to pay rent and the food bill, and car repairs are not in the budget. So we're trying to see what we can do. Doing anything fun for the 4th? I've already bought the fireworks we're going to use, and because it's been very dry, we're not using any fireworks that use lights, like lighters. We've got a case of poppets, those ones that you throw at the ground and they snap. That's it. So we're going to make a mess of the sidewalk, throwing those around and playing with those. They're not too loud. They don't scare the animals very much. As a matter of fact, I think Kiki chases them. So we'll do that and just probably watch a good 4th of July movie. Love True Crimes. Thank you very much for the awesome super chat. I'm not supplementing. What am I supplementing? What am I supplementing? Did I miss the conversation? Who is Kiki, your child? It's a cat. It's a cat that does not like caviar, by the way, Kathy. I tried to feed it. I tried caviar for the first time in my life, and it's terrible. Don't recommend. 3 out of 10. And it was good. It was expensive caviar, like nearly $150 for an ounce. I tried it. It was not good. It got worse over time. Tried to feed it to the cat. The cat wouldn't eat it. Tried to feed it to a possum. The possum wouldn't eat it. And then the only thing that would eat it was the fire ants. So I fed it to the fire ants. Special K, that would be the smoking gun in this case. I don't think they have it. It is circumstantial. Troglodyte. Oh. Yeah, probably. That's my classification. The drone displays are really cool. I don't know if we have any local ones, possibly in Raleigh. By those kids new. Kathy, I'm not sure about you, but I don't make that kind of money. I do not make that kind of money. I'm still trying to afford to do the repairs on my house. So. All right, we're back. We live pretty frugally, which allows me to live on YouTube money. But we've never bought a new car in our lives. Not from a dealership. Unless it's a used car dealership. That's where we buy from. Or possibly just someone on Facebook. Turn down the noise a little bit for a minute. Our financial decisions were inspired by my wife. So we don't have any debt, 0 debt, and it's amazingly freeing. But we also don't have really nice things.
Good morning, Detective Reese. Could you please state your full name for the record?
Detective Adam Reese.
Haven't we seen him before?
And where are you employed, Detective Reese?
Metro Nashville Police Department.
How long have you been employed there?
About 18 and a half years.
And what is your current position at the Metro Nashville Police Department?
I'm a homicide detective.
How long have you been assigned to the homicide unit?
About 5 years.
And can you describe, were you assigned as the lead detective for the homicide investigation into the homicide of Jade Tristan Benning?
Yes.
And can you explain what does that mean to be assigned as a lead detective to a homicide case?
So in the homicide unit, we have multiple detectives, obviously, and we have multiple deaths that need to be investigated throughout the year. So we have sort of a rotation that we go on between each of the teams. So when it's your turn on your team, you're assigned the case, and at that point, you're the lead investigator. So you make most of the decisions related to that case and utilize the help of your teammates to assist in that investigation.
And are you just working with other homicide detectives, or are there other units within Metro Nashville Police Department that assist you depending on the case?
Oh, depending on the case, we may work with our Titans unit. We may work with any number of the investigative units depending on some of the nuances of the case. The crime scene investigations, the crime lab, medical legal investigator that works for the medical examiner's office. We spend a lot of time communicating with the district attorney's office about any homicide case. Other agencies sometimes even.
And if you could just clarify, what is the Titans unit at Metro Nashville Police Department?
There's sort of a investigative support unit that helps with like surveillance, tracking fugitives down, that sort of thing, gang intelligence.
And do you have supervisors that you report to and request things from?
Yes, our team is supervised by a sergeant.
And can you describe how how did you become aware that you were going to be assigned to this case?
This particular week, we were on call for after-hours homicide call-outs, and I received a call fairly late in the evening. I don't think I ever documented exactly what time I got the call, but it was around 9 or 10 p.m. on the evening of the February the 26th, and Sergeant Chris Dickerson, who was my supervisor at the time, called me and advised me of a case I was going to be assigned.
Which that is currently Captain Christopher Dickerson, is that right?
Yes, he's been promoted twice, at least since then.
And you said that was 9 p.m. on February 26th, so that would have been 9 p.m. Sunday night.
If the 26th was a Sunday, yes, and I'm estimating it was 9, 10, sometime late in the evening.
So not on the 25th at all?
Correct.
And can you describe, explain what the logistics were of you getting called and assigned to this case at that point in the investigation versus you responding to Vanderbilt University Medical Center when Ms. Benning was transported there by ambulance? So
we generally do not take a case unless we've received information that the victim is not going to survive. So if someone is shot, say for instance, and the hospital says they're likely going to pull through, there's a separate unit that investigates non-lethal shootings and aggravated assaults, that sort of thing. We take it if it's going to be an actual homicide.
And when you were assigned, what did you do first? What was your first response?
Well, my first thing was just to get a quick briefing from Sergeant Dickerson over the phone to kind of learn some of the basics of the case. And then at that point, myself and several of my teammates responded to the headquarters where we had arranged for Jake Benning's mother and a friend of hers to be there so that I could begin interviewing them and finding out the circumstances of the case.
And can you describe why would you have them brought to headquarters versus going to them?
We usually like to do, as often as possible, we like to do interviews at headquarters because we have audio, video recorded interview rooms and also all the resources available in our office for if I needed to look up something on a computer or print out something to show them, that sort of thing.
And were they contacted and asked if they would come?
I don't recall the exact circumstances of how they were summoned, but I know they came willingly.
I guess that was the point of my question. You didn't have to bring them down there or anything, is that right?
No.
And can you describe what information did you learn in those initial kind of moments of speaking to Captain Dickerson and also speaking with Miss Jade Benning's mother, Bridget Burks, as well as Nigella Jackson?
Yes. So when I first spoke to Sergeant Dickerson at the time, he let me know that there had been a call the previous night in which the Domestic Violence Division responded. He said that there was a young woman who had gone into cardiac arrest and was revived either at some point in the process, and she was taken to Vanderbilt, and that a friend of hers had made allegations that she'd received a phone call saying that she'd been drugged, something to that effect, and that domestic violence had gone out and done some interviews, and they had gotten new information that she was not going to survive from the incident and reassigned the case to homicide, and it was my turn, so it was being assigned to me. So,
and can you describe your interaction with Miss Nigella Jackson?
Yes, we conducted an interview. I believe we started just a little bit after midnight, in the early morning hours of the 27th. She basically described her evening to me.
And can you, I guess, describe, was she able to give you specific details or what?
Yes, she actually was able to give me a very specific timeline.
And was she able to tell you specifically about the call that she received from Ms. Benning's phone and what she heard on that call?
Yes.
And did she give you very specific statements that she did?
Yes, she did.
And in the process of your investigation, did you review her prior statements to other officers and Detective Smith and compare it to what she told you?
Yes, because there was a recorded interview with Detective Smith, I believe, and then there was also body camera footage where officers spoke to her at the hospital.
And was she consistent in providing that same information every time?
Yes.
And what, if any, other information did you have at that point?
I had information that she was in a relationship or something, and she was pregnant with Mr. Taylor, and there was some ambiguity about the status of their relationship, whether they were just actually dating or she was just pregnant with his child.
You know, I'm going to object to the hearsay in regards to what Nigeria has said, as well as the bolstering of the witness through other statements she's made.
Okay, I don't know what you define as bolstering, but do you care to be heard?
Yes, Your Honor. Ms. Hollins cross-examined Ms. Jackson about one of her statements and said that she said something previously. She did not, and so I'm allowed to ask about her consistency.
Okay, I'll overrule the objection.
If you can
Yes,
continue,
defense
you
was
said
bad, so I
there
get to
was
do
some
this.
confusion as to the status of the relationship. Is that correct?
Objection hearsay.
That's just his opinion and why he's doing what he's doing, so let's get to where you want to go.
I guess, what did you do next, and did you gather any other information before you did what you did next?
Well, after I finished interviewing Ms. Jackson, one of my teammates had created a search warrant. He had drafted a search warrant to search her apartment. Before we went to the apartment, previously when I had spoken to Ms. Burks, she had explained to me that they had retrieved a comforter in which Jade threw up and vomited on from the apartment. So prior to going over there, that was secured in their vehicle, their family vehicle, in a bag. I went out and photographed that in the back of the vehicle and collected it and took possession of that. During that same time, one of my teammates had acquired the search warrant for Ms. Benning's apartment, and then we went to that location to conduct the search warrant on the apartment.
And can you explain why is it that you got a search warrant? Did Ms. Burks give you permission to go, or why would you get one?
We wouldn't even ask because all the information I had at that time was that that apartment was Jade Benning's and Jade Benning's alone, and Jade Benning was not in a condition to give us consent to search the apartment. So we generally get search warrants on every residence anyway.
Is that kind of a standard operating procedure?
Mm-hmm.
And that was the first moment that
This
the
court
search warrant
allows.
was obtained for that apartment. Is that
Mhm.
correct?
Yes.
Mm-hmm.
And I guess is that typical in a situation like this, or was this kind of an atypical situation?
No, this situation was unusual in that it had been with another unit who was handling it as a non-death scenario, then coming to us as a death scenario. So it was not typically done that way.
And Ms. Burks told you that people went to the apartment, and she said she had something from the apartment that she had to give to you.
Objection, leading.
He's already said that, so what's your next question?
At any point did she, I guess, express that she felt like she had done something wrong by going in the apartment, or did they feel like they could go into that apartment at the time they did it?
I don't think I didn't get the impression she felt like she did anything wrong, but she just explained to me that she named off.
Well, I don't believe that he's giving me her actual words, and I was just asking.
Okay, he answered that by his first word. She didn't feel that way, so what's your next question?
Detective Reese, is it possible that an officer with Metro National Police Department that was at the hospital told them they could go into the apartment? Do you know if that's possible?
It's entirely possible.
Okay. And I guess describe that process. Once you got the search warrant, what happened next?
So we met one of there were some patrol officers that had been already sent there by I believe the supervisor. And we all met at the parking lot of the apartment complex, which is in the 1500 block of Lebanon Pike here in Nashville-Davidson County, where this evidently had happened. And I met one of our CSIs there, and I gave him the comforter that I had taken possession of from Ms. Burks.
And would that be which CSI?
Mr. Terry, I believe. And then after that was given to him, or maybe while I was giving that to him, I believe our patrol officers entered the apartment with a key that had been provided and cleared the apartment just to make sure there was no one inside. And then we went inside and CSI did photographs of the apartment, and then we conducted a search.
And can you describe, were you present the entire time while that search happened?
Yes.
Was there any point that you would have been doing something else and not been kind of in that kitchen area of the apartment?
I wouldn't say I was in the kitchen nonstop. I went into other rooms.
And I want to show you what is part of Exhibit 16.
Ah, yeah, there's that water. Tag, hello. How are you doing?
Do you recognize that image, Detective Breeze?
I do.
And can you describe, there are 2 bottles that are on the corner of that counter. Did you put those bottles there?
No, I did not.
Do you have any idea who did?
I believe it was Detective Samuels who was with our team at that time.
Is that technically something that would have been done? Should have been done, I guess is my question.
No, because those were taken out prior to or during the time where CSI was doing what we call overall photos. They were taken out prematurely.
And also from this same exhibit, can you describe, there is a cup that is over to the right side of the sink.
Yes.
When you were there executing the search warrant, can you describe what, if any, relevance did that plastic cup have to this investigation?
At the time of executing the search warrant, there was it wasn't believed to have been relevant. The glasses that you see pictured here on the island were...
You can circle them.
Sure. These were thought to have been relevant based on the interviews I'd done earlier that night.
And why is it that those were the focus?
Because it was mentioned that they were drinking out of the glasses earlier that night when...
And can you explain what you mean by it was mentioned that they... What information?
During the interview with Nigella Jackson, I learned that she had stopped by Jade's apartment earlier in the night, and she had explained that Jade was having sort of a date night where she was cooking Alfredo and they were painting, and she was doing that with Mr. Taylor, and she explained that she loved Jade's chicken Alfredo.
The call going into your center. Okay.
About the Alfredo.
I was not getting that much detail, but...
Sorry about that.
That particular cup, again, at that moment, did you know anything? Did you have Jade's cell phone? Had you had an extraction done? Had you gone through it and looked at the pictures?
Now, I think we were in possession of her cell phone by that point, but we had not had the opportunity to be able to have it examined, extracted, or go through the massive amount of content on it.
If this witness could be handed, I believe it's Exhibit 21. I apologize. 28 is the iPhone.
Okay, you're being that humble. See if the clerk's back there.
Had 13 objections so far today.
We need Exhibit 28. Okay.
Do you recognize that item, Detective Breeze?
It's The envelope is sealed. May I open it?
Sure.
Yes, this is Jade Benning's cell phone.
Your Honor, at this time, I would ask that Exhibit 28 that was previously marked for ID be entered as Exhibit 28. Detective Brief, who did you receive that cell phone from?
I think it was Miss Benning's mother, Bridget Burks.
And can you describe when you obtain cell phones, having the passcode, is that useful?
It is very useful.
And did Ms. Burks provide you with the passcode to Ms. Benning's phone?
Yes.
Did she provide you with information related to Ms. Benning and kind of what had transpired from the time this happened until the time she met you?
Yes, she had.
And did she provide you multiple details about anything and everything that happened with that apartment and or her phone?
She provided me, everything with her apartment.
Did she tell you that people had been over there?
Oh, yes. She explained that people had been by there.
And was she freely giving you as much information as she possibly could?
Absolutely.
And later, I guess in the investigation, did you receive photos from Ms. Lauren Weber?
Yes.
And I want to go back to those. Those are Exhibit 13. Do you recognize those, Detective Reese?
Yes.
And if you could just read out the date and time.
That's February 25th, 2023 at 11:29 p.m.
Your Honor, very briefly, I wanted to make sure that I qualified it before we went too far. I have no issue with the phone itself being entered, but not everything on it. So if there is something within the phone, I would like.
Well, we'll get there if they're planning on introducing something else.
I just wanted to
The phone
make sure
itself,
that I could.
it was already made in it. All right, go ahead.
Thank you, Your Honor. Detective Reese, did you see this photograph kind of early on in the investigation?
Yes, fairly early on.
And do you recognize anything in that photograph?
Yes, I recognize the glass sitting there and the pieces of art on the counter and the painting supplies and accessories.
And this is the second photograph in Exhibit 16, in Exhibit 13 that was provided by Ms. Weber. And do you see the same two glasses from the other photos?
Yes.
And now I want to show you an image from Exhibit 29. This is after Ms. Benning's cell phone has been analyzed. Can you describe when you saw this photograph, did anything stand out to you?
That photograph was actually brought to my attention by Miss Burks. She mentioned to me that this one was taken that night and mentioned something.
If you'll answer the questions, you'll be here till 3 o'clock if you don't.
Yes, sir. Yes, this photo was brought to my attention.
And maybe I should clarify, did Ms. Burks show you this photograph before you received the extraction?
No, I received the extraction. I just hadn't noted that particular photo.
Okay. And can you describe that cup? When you saw it in this photograph, did you associate it with anything at the crime scene?
Not initially.
But we just looked at photographs from CSI Terry. Can you describe, kind of after you've looked at everything and talked about this, what do you see here now?
Yes. After some time, I realized that cup we didn't realize was even there. And then after time viewing this photo, noticed it to be in the background beside the sink there.
Can you describe, did you ask anyone to collect that cup?
No, we did not the night of.
And why?
We did not realize it had any relevance to the investigation. It appeared as though it had been just washed and put aside to dry.
And can you describe, did you direct them to collect items from that apartment?
The CSI, yes.
And after that was done, what was your next step?
My next step was I wanted to try to find out what we had going on. So there's going to be a series of tests requested related to items seized from the apartment.
Can you describe at that point on the 27th, did you have any clear idea of exactly what was going on?
Not yet at that time.
And so you said that you were going to run some tests. Can you describe at what point did you receive information from Vanderbilt Hospital about any laboratory testing?
I was eventually told that there was a secondary urinalysis done that came back positive for cocaine.
And was that the information you received, or did you have lab work with values and things of that nature?
I didn't have any lab work. I was verbally told that it was an initial screening done, it came back negative, and then I believe sometime on the 27th I was notified then that, okay, there was another screening that came back positive. I didn't know why that discrepancy was there.
And positive for what?
Cocaine.
And can you describe what are the next steps of your investigation?
I submitted a series of requests to test the glassware, the samples of some of the beverages, and eventually I requested that the lab test the comforter that had been seized to test the vomit to determine if there was cocaine in the vomit.
And was that done kind of later on in the investigation when you had received some more laboratory results?
The comforter was done, I believe, later. I'm sorry, do you have the Form 282s?
Honestly, I feel like we've talked about laboratory testing. I'm sure it's documented in an exhibit. I will move on. Who was the next person that you interviewed? Or can you just describe your investigation? At that point, what are you doing?
Well, later in the day on the 27th, I went to Mr. Taylor's house to attempt to speak with him. And then after that, I was just trying to have lab requests done to determine what samples were there. Also, early on in the investigation, I was just doing research I was doing Google searches, trying to get some idea of what happened.
Prior to this investigation, had you ever worked a poisoning investigation before?
No.
And can you describe the specifics of this case? Had you ever had anything that dealt with oral ingestion of cocaine?
No.
And can you describe what, if any, investigation did you do related to those kind of facts of this case?
Well, in the first couple of days of the investigation, I did some internet research, just checking something that...
Okay, he's answered your question.
You said you did some internet research.
Yes.
I Googled
was there information available on the internet?
Yes, there was.
And can you describe, was it one site, or did you find multiple sites with relevant information?
There were multiple websites from universities, government websites, and recovery websites.
And did you do anything else other than internet searches?
I did. I reached out to a detective that I knew that had experience working drug investigations.
And the investigation that you did on the internet and speaking with that detective, was it consistent or inconsistent with the facts of this case?
It was consistent with the facts of this case.
And can you describe kind of what interactions did you have with laboratory testing requests and kind of all of the lab results that you know that we have back from NMS labs as well as MNPD crime lab as well as CFSRE lab?
So there was the testing on the beverage samples and the drinkware from the apartment had all come back negative after being tested at our crime lab. I did a lot of coordination with the crime lab director during that time, and it was explained to me that it was not within their capability to test the comforter for what we were trying to do, and that it was going to be outsourced. And I was told that would be outsourced, and I received results for that several months later. And then also in shortly after the autopsy, I was advised of another sample collected at Vanderbilt that was being sent off for toxicology through the medical examiner's office.
Did you meet with Dr. Carney during this process?
Yes.
And can you describe, were you making every decision about lab work, or who all was involved in this case that was kind of requesting the different laboratory testing?
I was coordinating between a toxicologist with Vanderbilt, I was coordinating between Dr. Carney, and I was speaking with the director of the crime lab at the time, the acting director, Amanda Sweet.
And at some point, did a group of those people, along with myself and Deputy Moore, and you all get together to meet to kind of discuss what the evidence was in this case?
Yes, we did.
Is it fair to say that none of us didn't know anything about it, and we needed them to kind of educate us about it?
That's very accurate.
And can you describe, once you received the extraction from the cell phone, is that something that you would look through by yourself, or how does that work?
I usually would look through it in conjunction with one of our SISU detectives, which is the Surveillance and Investigative Support Unit. They do digital forensics.
And Detective Tom Miller is in that unit, correct?
That's correct.
Did you work with him and meet with him during the investigation process?
Yes, we work in the same building, so I would talk to him on a regular basis about this.
And again, Detective Blaise, kind of at that early outset, you had the information from Nigel Jackson. Did you ever speak with Mr. Keontae Jones?
I did.
And was that an in-person interview at headquarters, or what type of interview?
I just spoke to him by phone.
Is it possible that he might not remember that specifically?
Speaking to me by phone?
Yes.
I suppose it's possible.
Did he provide you with information?
Yes.
And so, kind of in those early stages of the investigation, is it fair to say that you were unsure of the exact timeline compared to today, where Dr. Carney has given us a very definitive timeline?
Yes. Yeah, I was not sure of there was a lot to be discovered and found out and put in order.
And so can you describe what information, what were you looking at within Ms. Benning's phone, kind of for purposes of your investigation?
I was trying to look for anything that seemed like it might have been relevant to the investigation. You don't always know exactly what's going to be relevant sometimes until you find something.
Were you specifically looking for cocaine?
Oh, yes. I was looking for anything that I could find having to do with drugs, any that I could think of.
And I guess, can you describe, did you find anything in her phone that indicated that she had ever used cocaine?
No.
Did you look, can you describe how much information was in her phone to look through?
It was a very, very large amount. Thousands and thousands and thousands of text messages, photos.
And can you describe, were there any references to narcotics at all in Ms. Benning's phone?
Yes.
And those references, can you describe what type of narcotics were referenced?
Marijuana, and on one or two, or a couple of occasions, a mushroom bar.
But absolutely nothing related to cocaine, correct?
Correct.
And can you describe, did you look at kind of the timeline of when Ms. Benning became pregnant?
Yes.
And can you describe, after she became pregnant, what, if any, references in her phone were to marijuana?
There continued to be references with the person, with the contact that I ascertained to be her dealer, but they were always...
Would that be Danny Weed?
Yes. And they always appeared to be her facilitating for other friends, co-workers, and things like that to get them marijuana.
And specifically, did Ms. Benning have a communication with Danny Weed on February 25th of 2023?
Yes, she did.
And did you look back at that and locate the message that preceded her contact with him?
Yes. Another person, I believe it was one of her co-workers, specifically asked her to reach out to him to get a half, which I ascertained to be a half ounce, based on my knowledge of the lingo.
Did you speak to multiple friends and family of Ms. Benning?
I did.
Did you find any evidence that she was using drugs or alcohol after the time she became pregnant?
No, I did not.
And can you describe what, if any, investigation did you do related to Miss Nigella Jackson?
I reviewed her messages with Jade.
Were you, I guess, had you already decided what happened, or were you investigating to see what evidence was there?
I was trying to see what evidence was there to add that into my, factor into my findings.
And can you describe, I guess, the volume of communication between Miss Benning and Miss Jackson that you found?
They communicated on a very regular basis.
And were you looking at the content of their communications to determine what their relationship was?
Between Nigella and Jade, yes. I mean, I was factoring that in. It was clear to me that they were close friends.
And can you describe what, if anything, was in Miss Benning's phone related to Miss Keontae Jones?
To Keontae? I believe he was only referenced with Nigella when she was coming over. That's the only time I remember seeing his name pop up.
So it's fair to say that they did not have communications between each other?
Not that I found them.
And can you describe what, if any, investigation did you do into Miss Benning's contact with Mr. Blaise Taylor?
Yes, I reviewed messages between them.
And can you describe, did you review all of them?
I believe I reviewed close to all of them. There were a lot.
And were you looking at the content of those messages to kind of develop a timeline of events of when things happened?
Yes.
And were there specific things that stood out to you within that timeline?
Oh, yes.
And you have Miss Benning's phone. We saw that cell phone sitting on the island in that picture that we just looked at from Miss Benning's phone. Did you ever obtain a cell phone from Mr. Blaise Taylor?
No, I did not. Well, not during that time frame.
Did you obtain any devices during that time frame of the early investigation?
Not from Mr. Taylor, no.
And can you explain what you mean by that?
Well, I just didn't get a phone or anything from him during that time frame. There were some obtained later after his arrest in Utah.
Was there a tablet that the Titans team provided?
Oh, yes. Yeah, they provided that, I believe, sometime maybe in the summer of 23.
He was arrested in Utah?
And we've already heard testimony on that. Can you describe, I guess we're kind of fast forwarding a little bit, but describe when did you obtain a cell phone related to Mr. Taylor? How did that happen?
There was one seized incident to his arrest in Utah that was held for me, and I flew out there to attempt to interview him and also get some items that were obtained during a search warrant by authorities in Utah, and I took possession of those and brought them back here.
And Dr. Carney's autopsy report was completed in August of 2023. Can you describe what's the time frame of when charges were sought in this case?
The case was presented to the grand jury on March 6th of 24, and I believe the capias was in the system as such that the U.S. Marshals could adopt it and go look for Mr. Taylor in Utah, I think by the 13th. And usually it's not uncommon for that to take about a week to get in there, and I believe he was arrested on the 14th of March of 24.
March 6th, which that date is significant in this case, but this is March 6th, 2024.
Correct.
And that there were not charges up until that moment. Is that correct?
That's correct.
And Dr. Carney's autopsy report was completed in August.
I would have to refer to the actual report. I believe that's correct.
That's what the report says.
Yes, that's what I would defer to is what the report says.
Can you describe the cell phone? Were there other items that were seized that belonged to Mr. Taylor?
I believe there was just some laptops and iPads, a GPS tracker. I'd have to look at the inventory sheet, but it was several iPads and a few laptops and a GPS tracker, and there were a couple of USB flash drives.
And did you locate a cell phone that would have been the cell phone Mr. Taylor was actively using using on February 25th of 2023?
No.
So what, if anything, in the investigation did you do attempting to find information about what Mr. Taylor might have been doing on a cell phone?
I wrote a search warrant to search his iCloud account.
And did you receive a return on that?
Yes.
And can you describe, did you review messages in that iCloud return?
Yes, I did.
And were there messages between Mr. Taylor and Ms. Benning?
Yes, there were.
And were you looking to kind of sync those up with the messages on Ms. Benning's phone?
Yes.
And as part of that, I guess, can you describe, as you're looking through information, are you continuing to meet with and kind of discuss things with Detective Tom Miller?
Yes.
And specifically, was there something that you were looking for related to that iCloud account?
Yes, I was trying to find, due to the volume of information on there, I was trying to look through keywords for things that may have been relevant to the investigation.
And that extraction of the iCloud, did it provide you with Google searches?
Yes.
And can you describe the number of Google searches?
There.
All right, the judge says yes, you can approach as we get to the Google search. There's an objection here. Obviously, the defense does not want this part in. We'll see if they're successful in keeping some of these out. Might take a minute here for them to sort this out at the sidebar. Oh, we missed the ASMR on the water. Bummer. Bring on the Google searches. I don't know what they're going to say. I'd love to know. I have RA YouTube in my phone. Yes, please add me. There you go. And we can still hear we still get the coughing. Needs more water. Could be really important. We're also laying the foundation for Apple, right? We're getting there. Did he just spray something in his mouth? Was it Banaka? Wasn't mace, I'm sure. This is when it gets good. His iCloud account is searches. I don't see how they could possibly keep this out. Maybe with a caveat, Blaise device searched. Blaise, he did turn over a bunch of old devices. The detective has testified that he did not turn over the current device, or he didn't gain control of the one he currently was thought to be using. Apparently the gold is outside the scope of the dates. Scored it 3 times. Did they still make Banaka? I was a kid. That was like, it's like how many squirts could you tolerate before it, burned your mouth off? Yeah, here we go. We're coming back.
All right, what's your next question?
Detective Blaise, did you notate specific things within the messages where, obviously, Detective Miller has already testified in this case. Did you have additional messages that you reviewed that kind of related to that timeline between Ms. Benning and Mr. Taylor?
Additional messages?
In addition to what Detective Miller already testified to?
There were several, I don't know exactly what he testified to, but I reviewed several messages related to their conversations.
I have a 4-page text message thread. It begins on January 8th, 2023 at 1:06:09 p.m. It goes to January 8th, 2023 at 2:10:25 p.m. I would ask that this be handed to the witness. Defense counsel's been provided a copy.
All right.
He's arrested in Logan. Seriously.
I just read the first one. And the very last
Used to live in Logan a long time ago.
grade 8. Oh, that one.
Judge, I'm sorry, I gave this to them to review so that we could look at them ahead of time, but the pages have been mixed up. Can I have that back so that I can fix it?
Oops.
Do you have the January messages? You gave them back to me. Okay, that makes more sense.
Yeah, it sounds like Google searches sort of got skipped. Yankees, yes, it's live on a Saturday.
Do you recognize those, Detective Reese?
All right, he hasn't been given anything.
I'm sorry. I take it back. Judge, may I take a quick break just to make sure we're all looking at something? I did show these to them ahead of time. I showed them to Mr. Grant, but I feel like when everything was given back, they are mixed up, and I would prefer that they be in order.
Okay. How long do you need?
I feel like just 5 minutes, but I might need those back from them because, like I said, they're all mixed up.
All right, ladies and gentlemen, the jury, your lunch is waiting for you, so if you'll step down the hallway.
All right,
break
lunchtime
for
it
an
is.
hour.
Judge says we're going to break for an hour, which means we get to take a lunch break as well today, which is nice. This will be day 5, part 2 this afternoon. We're going to portal over to that. And it's 1:30 now. We're going to start at 2:30. And we're done. You want 5 minutes? I'll give you an hour, says the judge. Fire Girl handmade by Wendy, first in chat on the new live stream. Let me go ahead and pin her comment as well as portal us over to the other afternoon session. It's the rare Saturday court appearance, which typically all of us would have the day off, but we're working today because the judge wants to get through this case and get it to the jury with them to have enough time to go ahead and reach a verdict before July 4th, which is the end of next week, before the holiday. Want to be done by then. So just able to tune in. Did I miss anything good? It's getting there. The defense is doing the defense thing. They've been consistent throughout this trial, which looks painfully slow at times, but they are very, very thorough. They've been pushing to keep evidence out of the trial. That's their big push. That's when you see the biggest fight from them, whether it's the blood test, the urine test, the comforter, the vomit tests. They've been trying to attack the chain of custody on all of those, the process that was done, the test results on all of those, and they've just continued doing that. We're now getting into a different area where we get into more digital evidence, which is brand new, so we're excited for this afternoon. Digital evidence oftentimes is quite telling, so text messages back and forth. Then we've got words straight from the defendant, things he said himself. That's going to be exciting. So we're just getting started on that one. Caviar for lunch. Purple coconut. Why? Why ruin it? Why ruin it? Going to fill the bird feeders. They need lunch too. Let's see. Sausage and salad. I think I'm going to do some... what are they? The beef hot dogs. I think we have some of those left. I think I'm going to cook some of those up and eat those for lunch. So We're going to take a break, give you some time to get some lunch or get some chores done or get dressed, if as the case may be. Some of you just waking up and still relaxing. Humans are meant to work on Saturday. I don't know. I try not to as much as possible. Kathy, good to have you here on your birthday. Hope you're enjoying it. We were on break like Ross was. Little Friends reference there. All right, we're going to be coming back here in a little bit to courts. We've got a portal that'll bring you right back to where we continue to follow the case throughout today as the state finishes up their case in chief and defense possibly opens up with their witnesses on their case. So it'll be fun. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 50 minutes. About 50 minutes. You don't see the portal? Let me make sure it's there. Hang on one second. It's there. It's there. Squint at the light. When you see it, when it gets brighter and the spot gets bigger and bigger, just squint at that. It turns into a portal, I promise you. All right. Portal buddies, fast. Grab somebody's hand. We'll see you guys after lunch. Bye-bye.
Happy birthday. You look good.